For judgment, item number 1, JCRLA 85 of 2006.
Appeal is dismissed.
Right. Item number 2, JCRLA 88 of 2006.
Appeal is partly allowed. The order of conviction is sustained. However, the appellant is found guilty for an offense of culpable homicide, punishable section 304, part 1 IPC, instead of section 302 IPC. And accordingly, sentenced to RI for 10 years and to pay fine of rupees 2,000 with a default sentence of RI of 3 months.
called at 10:30 am. Supplemental list item number 12, WPC 7469 of 2017.
In item number 12, my lord, some interim application intervention petitions are there, my lord, for Rajnagar Tahsil. You will also may dispose of that in as per the order dated 4/4/2020.
All right.
I am giving the numbers of the.
Yes.
Lordship, in this case, we are for the few of the intervener. In spite of specific notice for Lordship, the collector Khordha has started the demolition drive, Lordship. That is in your Lordship on last occasion, that is on 6th April order was there. Collector Khordha is to seek the
all these IAs, you say, all these IAs disposed of in terms of the order dated
4/4/2020.
4/4/2022.
Lord, sir,
My lord,
I have
I have
also filed an application.
IA number 5545 of 2022. My name has been come, but my IA number has not been come, my lord.
It will come on the next date, but so far as the present IAs is concerned, the Lordship may kindly find, I have filed objection in 7 IAs, and I have also filed 4 affidavits of 4 collectors. Today, these are the affidavits filed on my behalf. And the objections which I have filed all relate to Khordha district under Chilka Tahsil and Tangi Tahsil.
Yes.
The basic objection which we have raised, or objection, or your Lordship can treat it as our stand, that within 200 meters from the high tide line, as per the CRZ notification, there is a prohibition and no construction or anything can be allowed. Beyond that, there is no restriction. And I have stated in my objection and in which plot, which area is not coming under that restrictive zone and which is coming under the restriction. That's all. And accordingly, the IAs can be disposed of.
Let's see, I may pardon to say, in this case, this CRZ zone in Chilka, across Chilka, that has not been determined, Lordship. In specific in way, your Lordship, in IA number 13656, the first IA, Lordship, that is your Lordship's order from 6th April, that is 13647, that is my recorded land, that has been demolished completely, Lordship. During
Yes,
this.
let me submit. So far as this IA of my learned friend is concerned, unfortunately, I couldn't get the copy. So may I request to serve a copy today? I will file objection within 3 days. These two I couldn't get, 13647 and 18110. I don't know who is 18110. Somebody Vishnu? These two, your Lordship may kindly see the last order, para 19 above. These two IAs, I have not filed the objection because I couldn't get the copy of the IAs.
All right, 13647, IA
18110.
no, of which year? 13647 of 21.
All are 21.
And 18110
18110
of 2021. Copies of both IAs, additional copies of both IAs be served on Mr. D.K. Manti AG during the course of the day. Replies be filed within 1 week.
Lordship, there are 7 in your Lordship's order on 6th April, there are 7 IAs. Your Lordship just have a glance to the 6th April order, the next page. That is IA number 13647, 1800,
Others I have filed objections.
Lordship, that objection copy may can be served to us. In the meantime, status quo may be maintained, kind Lordship.
No.
In this case, Lordship, the farmers, they are putting in the severe problem to the farmers, fish farmers, Lordship. In the name, no farmers in under the Tahsildar Chilka and Tahsildar.
Let them file a reply, sir. Let them file a reply. The remaining
My lord,
I have filed an application.
18361, 18770, 18360, 19200, and then 1583 of 2022 and 732 of 2022.
Yes.
Replies have been filed in all these IAs stating that wherever the shrimp farms are beyond the
200 meters
200
from
meters, beyond 200 meters of the high tide line,
the high tide line.
no action would be taken. Full stop. However, dairies and earthen ponds which are within the 200 meters of the high tide line would be demolished.
Obliged.
Full stop.
Lordship, in the meantime, they may demarcate the high
In view
tide
of
line.
the above clarification, the corresponding action is permitted to be taken by the opposite parties in the event the prawn giri and earthen pond are within the 200 meters of the high tide line.
My lord,
Application
I am
is
in
disposed
receipt,
of
my
in
lord.
above terms.
My lord, I am in
I have
receipt.
I have filed an application for intervention, Lords, that is IN number 5774 of 2022, my lords. I've already solved the copy. My lords, my lords, prawn culture is 2 kilometers away from the Chilka Lake, and I have
Let them
no,
find out. Let
my
them
lords. Let them take instruction,
Copy
lords. Copy देइछा ओटा दे दे.
5774. I have 5774 also. To add in that.
My lord, I have also filed an intervention petition, IN number 5545 of 2022. I am in the Kendrapada district, my lord.
All right, you add
My
this.
name
You'll
has
have to
been
serve
found.
copies today itself, sir, on Mr. D.K. Manti.
Oblige, my lord.
Your Millards, so far as flag number 161, I have filed I number 4462 of 2022. In that case, the government has filed objection. In my IA, Millards, there are 14 applicants and all the lands belong to the Sthitiban land. If Millards, these lands are Sthitiban land without any notice, and
Sir, same thing, sir, it's 200 meters high tide line. That's the same
but
yardstick for
even if
everything.
Millards, even if
Paragraph 7 of my objection.
my respective submission, even if it will comes under the high tide line zone of the area, they can demolish without any notice and without giving opportunity of hearing also. Number one.
So if you admit
Number
it is,
two,
if you admit it is within you 200 meters.
no,
high
this
tide
is my
line.
Sthitiban land, my lord. This is my Sthitiban land.
So you cannot have prawn cultivation.
No,
within
there is
200
no,
meters.
that is crux of the case. There is no prawn culture within the Khordha district that has been reflected in the affidavit
Now,
filed by
what
the
are they
collector.
demolishing according to you then?
My lord,
What are they demolishing?
they have demolished my pisciculture pond. They have admitted there is no prawn culture within the district of Khordha. That is collector's affidavit, number one. Number two, that my lord, salinity of the water of that area does not provide for prawn culture because less than 5 ppt of the salinity is there. So there is no question of prawn culture. But I have, this is a case where lords, my Sthitiban land and my without any notice, they have demolished my land, number one. Number two, they are taking plea of 200 meters. My lord, kindly see the Act 1380. Where from they get 200 meters, my lord, kindly see 1380 of the Aquaculture Act 2005. I mean, allowed to read, my lord. Here was 13.8 says, notwithstanding anything contained in the section, A, no coastal aquaculture shall be carried on within 200 meters from the high tide line. But no coastal aquaculture, I am not performing any coastal aquaculture. Number two, no coastal aquaculture shall be carried on creeks, rivers, and backwaters within coastal regulated zone declared for time being under Environment Protection Act 1986. Since I am not performing coastal aquaculture, by the question of applicable to 13.8. Number two, that CRZ notification has come in the year 2011, reducing from 200 meters to 100 meters. That has been accepted by the state government. State government himself has filed an affidavit here, enclosing 2011 CRZ notification, where that has been reduced to 100. There is no question of 200. By name of the High Court, Honorable High Court, that Collector Khordha is demolishing haphazardly without giving any notice, without adhering to the principles of violation of natural justice. These are my Sthitiban land. Without any notice, forcibly they are demolishing. And whereas I am not performing aquaculture, coastal aquaculture act.
Yes, Mr. Manti.
Yes, my lord. The objection filed by me may kindly be seen. All these plots are what my learned friend is saying, that are Sthitiban plots, but they are Sarada. The kisam of the plot is Sarada, not for, that is for agricultural purpose, not for pisciculture. Now, para 7, I am just placing before Lordship. What they are saying that they are doing pisciculture business, pisciculture activities over that prohibited area. Admittedly, it is within the prohibited area. So prawn culture and pisciculture may be different, but pisciculture is also not permissible as per CRZ notification. I am just placing para 7 that it may be stated that first, your Lordship will kind enough to find that these are all agricultural land as per their record of rights, which I have stated in a tabular form at page 3 and 4 of my counter affidavit. It is approximately 1600 meters long and separate the Chilika Lake from the adequate aquaculture ponds present in the area. The no development zone in the said area is 200 meters on the landward side from the Reghwari Bandha. Since as per the OSARC map, the high tide line is congruent with the Raghurai Bandha. The lands of the applicants are coming within 200 meters zone partly. It is stated that any demolition will be undertaken from the ponds activities within 200 meters of the high tide line. We are not going beyond that. Whatever you are doing pisciculture activities within 200 meters, that is prohibited in law. That is why we are taking action. Not that it may be your Sthitivan property. We don't dispute that. It is a Sthitivan property. It is an agricultural land as per the Kisam noted in your record of right, and you are doing pisciculture business, which is prohibited, which is not permissible under the CRZ. And at this stage, I would draw your Lordship's kind attention at flag 102, the affidavit of the fisheries officer at flag 102. A CRZ notification is enclosed as Annexure 9 at page 54.
102.
Annexure 9. Lordship may kindly come to page 63. Area up to 200 meters. This is at flag 102. Abhiram Naik is the deponent. Has your Lordship got
One.
CRZ 3, page 63.
Which is this IA, sir?
No, this is an affidavit of the fishery officer at flag 102. Affidavit is dated 16th December 2021. 16th December 2021 at flag 102. May I give the copy?
I think so.
The 2011 CRZ notification, my learned friend is placing that. That portion I'm placing. That area up to 200 meters from STL on the landward side in case of seafront But this is applicable to sea, not Chilika. Next is, and 100 meters along tidal influence water bodies or width of creek, whichever is less, to be earmarked as no development zone. So far as Chilika is concerned, 100 meter, and so far as sea is concerned, 200 meter.
That is
CRZ 3, my lord, kindly will find page 63. My learned friend is referring that. Page 63.
yes. CRZ 3.
My lord. Area up to 200 meter, my lord, kindly see. Area up to 200 meter from height tide line on the landward side in case of sea front. That means sea. This is applicable 200 meters to the sea and 100 meters along tidal influence water bodies or width of creek, whichever is less, to be earmarked as no development zone. So 200 meters is applicable to sea, 100 meters is applicable to Malad Chilika. That has been clarified that my lord will find from the first page, page 54.
So yours is at what distance?
My lord,
Your pisciculture pond is at what distance?
sorry, my lord,
Pisciculture pond is in which, what distance? Amara?
my 100 meters away. My ponds are 100 meters away. And there is a in between, there is a Raghurai bond constructed by government. It means Chilika is separated from Raghurai bond. Raghurai bond at our land, in between there is a bond constructed by the government. It is called Raghurai bond. So we are not encroaching Chilika.
Raghurai Ghara is also consisting of around 1200 acres of land that has been allotted by the government in 1978 for doing the pisciculture. K form they have issued, we have also paying the salami for doing the cultivation, fish cultivation. And in 90 till 2000 they take, and thereafter they stop taking the salami.
At best, they can go for 100 meters. They can't go beyond 100 meters. At best.
This Raghurai bond, what my learned friend is saying, we have specifically mentioned that the no development zone in the said area is 200 meters on the landward side from the Raghurai bond, since as per the ORSAC map, the high tide line is congruent with the Raghurai bond.
That has not been properly demarcated, Lordship.
We have explained that from which point these 200 meters or 100 meters, we have taken it Raghurai bond.
Not been properly demarcated, neither by the Fisheries Department nor even by the Revenue Department. Arbitrarily, Lordship, they are doing this demolition drive, Lordship, without hearing to the poor farmers of the locality, Lordship.
How do we resolve this?
My lord, besides these are not all are agricultural land, but that then your lordship may direct for a joint inspection. The along with
That's
the
the only
parties,
thing. You say there seems
the
to be a
fishery
dispute.
department
IA
and
number 4472
My
4462.
4462.
of 2021 or 22. There is a dispute as to whether the applicant's pisciculture ponds are within the 100 meters of the high tide line or beyond. Since this is a dispute, court directs a joint inspection to be undertaken by the representatives of the petitioner as well as the fisheries department,
And local administration. Tahsildar is a necessary.
along with the Tahsildar, to visit the spot and correctly earmark the area which is falling within the 100 meters of the high tide line and those areas that are falling beyond. This exercise be undertaken within the next 10 days on dates to be
My lord may say 15 days because
next 15 days on dates to be on mutually convenient dates to be communicated to the parties at least 3 days in advance. The report of joint inspection be placed before the court in the next day.
my lord may kindly note another submission of mine, that this being all agricultural land, as per the Kisam noted in the record of right, They are not permitted under the law
So that
to
we,
use it.
that we don't have to.
They have to
friend is
respond it. They have to
forgetting.
respond it.
Pisciculture includes agriculture. My
No.
friend is not forgetting
No. Pisciculture doesn't. Agriculture
yes.
is a different thing. Pisciculture, that he has to respond by way of affidavit. How pisciculture, I will show your lordship that how the
That will do the
agricultural
next
land cannot be used as pond. That is also not otherwise permissible.
This is not the proper forum to adjudicate.
So if it is beyond 100 meters, then we don't
Yes.
have to worry whether it's pisciculture or not. What about the other affidavits, sir? What about the other affidavits?
Then your lordship may place, see the affidavit filed by the collector Ganjam.
Ah.
OP number 11. And one thing I must inform your lordship that in the meanwhile, in all the 4 districts, we have already started this helpline number, and there is a registered helpline number. All the collectors have issued it, and it has been properly propagated to the general public that this is the helpline number. You can lodge your objections, and Mr. Amicus Curie also is aware of this. And if your lordship will see the affidavit dated 29th April 2022, filed by the Tahsildar Ganjam.
So the re-emerged illegal net.
Yes, that I have.
Of 83 hectares.
I have clarified in para 3 of my counter.
Mr. Agarwal, this is Ganjam.
Yes, your lordship. The problem of re-emergence is there, which they are looking at. And even in traditional this farming, the distance between two these which are known as khandas, bamboo sticks, it should be 500 meters. But here it's less than even 5 meters. This is leading to exploitation of the lake. Right? The ecosystem is getting degraded, over exploitation. So that they should
500
see.
meters where it is.
That government's
provided.
guideline is there.
Guideline.
Government guidelines. So that they should look at. I'll also supply it to my learned senior, those guidelines. They should see that there should not be over exploitation of the lake.
My lord, I have explained in para 3 of my affidavit, your lords may kindly have, that I'm just reading para 3 of the affidavit of Sri Aruna Kumar Naik, Tahsildar Ganjam, that as pointed out by learned Amicus Curie on 6/4 and 7/4, a joint visit to the. Has your lordship got it? Yes. A joint visit to the areas to examine any erection, re-emergence of illegal gheris has been carried out or not. Upon reaching the area in question, it was noticed that there are no prawn gheris with zero nets. It was observed by the DFO, BNT, Baluga, and Assistant Fisheries Officer Ganjam that the enclosures have been erected with 20 mm nets, which is a traditional fishing technique used by the local fishermen. It is stated that use of 20 mm nets do not involve in creating a closed enclosure. There is a free flow of water, unlike in the case of zero net gheris. In the traditional fishing technique, there is no uses of any harmful chemical substances. The uses of khanda does not lead to any adverse effect on the aquatic ecosystem. The inspecting team did not find any prawn ghery with zero net. The answering deponent annexed herewith the photographs of the inspection carried out on this one. The aforesaid fact is also evident from the joint spot visit report dated so and so. These are annexed to H/11.
On over exploitation, it's okay. Whatever you want to give them, you can give them.
Yes, your
You say an affidavit has been filed by the collector, by the Tahsildar Ganjam, dated 29th April 2022.
This affidavit on behalf of the
Area
collector
stating that a
Ganjam.
joint visit was undertaken on 6th and 7th April 2022 to the areas to examine if there is re-emergence of illegal prawn gheris. So it is stated that, open quotation, the use of khanda does not lead to any adverse effect on the aquatic ecosystem, unquote. It is stated that the inspecting team, open quotation, did not find any prawn ghery with zero net, unquote. Photographs of the inspection have also been enclosed. Paragraph Mr. Mohit Agrawal and Senior Amicus Curie states that he will hand over to the Mr. Monty Learned AGA literature concerning steps to be taken to avoid over-exploitation of the resource for the purposes of fishing, is it?
Prawn culture.
Or prawn culture. On the next date, an affidavit will be filed on this aspect by the Tahsildar Kanjur. What about the other two affidavits?
Yes.
Khurda?
Those affidavits relate to other
My
three
lord.
districts.
My interim application
Quote. IN number.
113, IN number 18361, my lord. These petitioners are, my lord, traditional fishermen.
1 minute, sir. 1 minute. You can't suddenly start like this, IA.
18361.
Which is the second affidavit? 1 minute, sir. You have suddenly butt in when we are dealing with something else. What is this affidavit of the collector Khurda, sir? Tell us.
Collector Khurda. Yes, my lord. Yes. Sorry, my lord. That helpline matter, we have stated that it is, and so far as para 5 may kindly be seen. It is stated that the coastline of Chilka Lake has been under regular patrolling and no re-emergence of gheris in any form whatsoever has come to the notice of the administration. Patrolling the area is being taken up by the Tahsildar Tangi and Chilka for 2 days in every week. As reported by both the Tahsildar, the patrolling teams have so far noticed no re-emergence of illegal gheris which have been evicted. Copies of the, yes.
Anything?
And
Yes, ma'am. They have served me the affidavit just now, but it is fine. The work is going on fine there in Khurda.
and details I have given in page 4 in a tabular form. 4, 5. These are the evictions which were undertaken.
All right. The Tahsildar Tangi, District Khurda, has filed an affidavit. Dated
Fourth and month-wise breakup is para 7.
2nd May 2022. Inter alia, stating that in compliance with the directions issued by this court on 6th April 2022, a 24-hour helpline number has been made operational at the Collectorate Khurda to enable the public to report about illegal prawn gheris. Full stop. It is further stated that the coastline of the Chilika Lake is under regular patrolling and no re-emergence of gheris in any form whatsoever has come to the notice of the administration. Full stop. It stated that demolition drive is being conducted to evict the earthen gheris within 200 meters of the HTL, known as single quotes, no development zone. So the figures of demolition of earthen gheris after the previous hearing on 6th April 2022 have been set out as part of the affidavit. For the present, no further directions are called for as far as the Khurda district is concerned. Kendrapada?
They were in Kendrapada, they were to reconcile the satellite maps with the ground, which has not been done till date.
It is going on, we need some time. That's what my learned friend amicus query. Para 4 and 5 we have explained. Para 4 and 5.
Anyone in Kendrapada, any grievance?
Sorry,
Any grievance about the Kendrapada?
no, Your Lordship.
All right. The affidavit filed by the Deputy Collector Bracket Revenue, Kendrapada Collectorate. Date 2nd May 2022 has been produced. This is more or less in the same lines as the affidavit filed on behalf of the collector. takes note of the developments as stated there.
Puri, there is a very peculiar thing your lordship will find. After we set up a helpline number, some complaints were received and we acted upon it and we demolished the illegal carriage and we have booked the persons to criminal case and everything that I have explained in para 8. So this is a remarkable development pursuant to the honorable court's order. After this helpline number is started.
The affidavit of the collector Puri reflects that good progress has been made in the implementation of the court's directions. Photographs of the eviction process of illegal eviction of illegal garris have been enclosed with this affidavit. FIRs have also been lodged against the violators. So, the court would only like to emphasize that these efforts must be kept on without to ensure that there is no re-emergence of illegal prawn garris. Now we'll have it soon on the reopening.
After vacation.
That's right. Soon on reopening. We'll have.
On the date of reopening?
No, 23rd June.
3rd June.
No, 23rd, sir.
Obliged.
23rd June.
My lord, one thing may I respectfully submit, after this interference by this honorable court, now in almost all the 4 districts, there is less re-emergence, there is less, all these activities are controlled.
All right.
And my learned friend who is actively involved in this case, Mr. Amicus Curiae, he will also acknowledge this.
At least your lordship's pressure should be there. That is all.
Yes. Your lordship should have control over this, but now the things are going on very smoothly and organized way.
All right.
And your lordship, the issue of pollution, if your lordship may take the Chilika Lake, actually the river which drains its water into the lake, that is one river there. And there is one Gangua Nala flowing 16 kilometers long Nala through Bhubaneswar, and all the undischarged, untreated water from that Nala falls into that river, and that water gets drained to the Chilika Lake. So that river's water even not fish for washing the clothes. That is the report.
I think we're in a separate.
I think this is a case which is involved in that. Your lordship is hearing that matter. My learned friend and I will inform him. He will come on that day.
Affidavits, this BMC, and
in that case,
we are actually dealing with the river water pollution.
Yes, ma'am.
In the other one.
I will provide him the case number and date.
All right.
He will come and address.
All right.
My lord, my application.
Sorry, yes.
113 at flag 113.
113.
IN number 18361 of 2021. My lord, in that case, your lordship last occasion directed to take instruction and filed reply. They have not yet filed. 18361.
Yes, we have filed it.
We'll give you.
I'm giving a copy.
My lord, these lands have been duly supplied by the government to the present petitioner.
You see
that I have answered. So far as this lease is concerned, I have answered it in para 6. If your lordship will go through the objection in IA 18360 2021. 18360 2021. I have clearly stated at para 6. Should I read before that it is stated that from the field verification carried out on the basis of maps supplied by Orissa and Chilka Development Authority, the land in possession of the applicants comes within 200 meters of the high tide line described as no development zone. Initially, the lands under question had been provided to the applicants through Economic Recovery and Reconstruction Program (ERRP) scheme by the then Tahsildar Banapur, considering the financial status of the beneficiaries for a temporary period during the year 1997. It was not a permanent lease and the same was terminable at any time. Moreover, only 12 members of applicants were given such lease area with an area acre 650 decimal. each from government khata number 400 pertaining to plot number 1025 with Kisam Gocharo in Mauja Gopapur. No change. Gopapadar. No change has been effected in the status of the land so far. Hence, the applicants cannot claim equity on the basis of the prolonged farming carried out on the lands which has not been assigned legally. To this effect, the Tahsildar Chilika has also submitted a report to this office of the collector Khurda on 13/4/2022.
Examine the reply, sir. If you want to file a rejoinder, you file.
Rejoinder he can file.
My lord,
Yes.
my lord, since your lordship in previous order, you observed that a joint verification is required.
No,
In my case, my lord, it is beyond 100 meters away from the Chilika. There is a road separated from lake and pond.
Which
No,
We are
but so far as his right to cultivate also, that is also I have challenged.
Which district is this?
District Khurda.
For the
Same Tahsil, perhaps, if your lordship will say, we can also undertake the inquiry. But here is our defense is something else. Because what the lease which he is relying upon, that is a very temporary period under a particular scheme. That scheme is no more.
My lord, since there is no application of the life, my lord, your lordship may kindly bear. I have provided the documents which is of the year 1984 to 85.
No, that period is
And
over.
till
you
that,
say,
my
sir.
lord, no.
In Mr.
We are-
Pradhan's case, that was a Stitivan land. That is why your lordship has directed that you conduct inquiry and see whether it is coming under. But here they have no right over the land. The lease which they are relying upon, those are 1997 for a particular period. It is a temporary lease, does not confer any right over them.
Lordship, it is a kind of beneficial step taken by
My lord, they have
That
taken
scheme is no more.
My lord,
the poorer people of
we
the
have
local
deposited the
Chilka.
amount in the year 2009 till 2009. But they thereafter they did not allow me
Let them
to
file
deposit
rejoinder to
money.
this objection because a factual issue I have raised.
And
18160.
18360.
361, my lord.
18361. I'm very
361.
sorry. 361. I'm sorry.
361 of 2021. You say reply of the state has been handed over to counsel for the applicant who's permitted to file a rejoinder before the next date. Same date.
My lord, I pray for joint verification physically, and we will provide the necessary documents
So,
before
sir,
the authorities.
First of all, whether the
My lord,
land,
it is- my lord, your
whether the
lordship-
land can continue with you or not itself is a question, sir.
Correct.
Where's the question of joint verification? All right.
Item 1, in this case, no instruction, madam.
No instructions disposed.
I am for the opposite.
Right.
May I please proceed? Your Lord, I filed a IA 16923 of 19 for substitution. That is not on the board.
It's all right. What is the matter about? What is the matter about?
My lord. The petitioner herein is challenging the order of the OA appeal case and also the OA revision case, my lord. Brief facts, my lord. The petitioners were admittedly the petitioners were the tenants, Kutta tenants under the intermediary, that is Madan Mohan Das. And my lord, they had filed after that, the land was vested with the government in the year 1953. But thereafter, after vesting, government has asked the petitioner for rent receipts for giving rents, my lord, and that is also evident in the Annex of 1, my lord. Thereafter, the petitioner filed a OA lease case before the additional Tahsildar, and the lease case, in the lease case, public notice was made and field inquiry was also conducted, and thereafter, the land was settled in favor of the petitioner. Subsequently, after the completion of the appeal period, my lord, the present opposite parties, they filed an appeal that is with a limitation, but there was no limitation petition in the appeal, my lord. In the appeal, they stated that they are also the tenants under the intermediary and the land may be settled in favor of them, but without any documents. Admittedly, that was without any documents. In the appeal, my lord, the subdivisional officer stated for in the appeal, they remanded the case before the OA, my lord, OA. that challenging that, I filed a OE revision case. Now that is also under challenge, my lord. Now, my lord, the main grounds of my challenge is that, my lord, the opposite party was not a
What is the order in the OA revision case?
My lord, that is annex to 6, my lord. Not to see.
4157.
Let me see page 38. My lord, before that, page 37, my lord. It was the third para. The learned advocate for the petitioner states that the petitioner is in continuous peaceful possession of the case land from the date of vesting. Accordingly, Tahsildar Nimapara settled the case land in favor of the petitioner, basing his possession from the date of vesting. The consultation authorities has also recorded the land in favor of the petitioner. A portion of the case land has been settled in favor of Bulla Naik, the opposite party is right now, the ex-intermediary. The position of the petitioner has been affirmed by the London Civil Court in Title Appeal number 19 of 1991 and 94 of 1991. The present OP Kundei GP utterly failed to produce any documents in his support. Section 73 of the GP Act provides provision for transfer of land in favor of the GP, the Gram Panchayat. In the present case, no such order. The consultation authorities has recorded the case land in favor of the petitioner. Admittedly, that has been also been recorded, and the final ROR publication has also been made, my lord. Now, as per section 51 of the Orissa Consultation and Prevention of Fragmentation Land Act, there is no bar of jurisdiction to challenge the order of the consultation in any court. No limitation prayer was also filed before the appellate authority, so the order of the remand passed by the appellate court is illegal in the eye of law, my lord. Now, the operating portion, my lord, let me see. Let me come to page 40, my lord.
Page 40.
Yes.
The second parameter. The Honorable Supreme Court in CA number 7670 of 1977, in such and such case, has held that the nature and character of the land being non-agricultural, the same evidently was not in cultivating position of the intermediaries, and thus an application for settlement of such land by the intermediaries purported to be in terms of section 7 of the Act was not maintainable. The land being anabadi in status with Kisam Padia as per 1928 ROR. So in the present case, the petitioner are not in khas possession of the case land and are not entitled to the benefits of section 7 and 6 of the OE Act. As a result, the revision is disallowed and the land be continued in the government khata. Then in the meantime, my lord, during the period of appeal, my lord, the consultation proceeding was held in the village, my lord. That has been completed. The consultation authorities also held that I was in possession of the land, and the ROR, the consultation ROR was also published. That has reached the finality. In the meantime, the title appeal, there is the opposite parties have also filed a second appeal. That has been dismissed before this honorable court. The second appeal now is dismissed. I've got the copies, my lord. So, my lord, my humble prayer is that, my lord, the present OPs had got no locus standi to file the appeal before the OE appellate authority because they were not the parties. The only authority that was to file was the government. Government had to file the appeal, but they have not filed any appeal that had reached the finality, and the opposite parties claimed to be the tenants and they filed the appeal. That is also beyond limitation. There was no prayer for limitation. That was beyond limitation. But in the OE appeal, he remanded the matter to the matter, and thereafter I filed the revision. Now these two orders are not challenged, my lord. Man, I've got two judgments, my lord. Lordship holding the Chaudhary Balram Das.
Yes, that's right.
My lord. Lordship see page para 6 and 7. Heard learned counsel for both the parties at length, peruse the matter with due diligence and consider summations meticulously. Admittedly, the lands in dispute were the part of an intermediary estate which vested with the government free from all encumbrances in consonance with the OEA Act. Law is settled that consequent upon such vesting right, title and interest of an intermediary vest with the state government, and he is stripped of such rights. The OEA Act is full-fledged act. It provides modalities for acquiring fresh title in respect of the lands situated in the intermediary estate after vesting. If any portion of the intermediary estate was in fact donated to Buddhan Samhita prior to vesting, consequent upon vesting, such rights abolished. Admittedly, no claim petition was filed by Bhushan Samiti opposite party 3 to 33, claimed to have acquired the title through Bhushan Samiti, but then whether the Bhushan Samiti was competent to settle any right upon opposite parties 3 to 33, and if it lost its title, if any, in consonance with the OA Act, is a question which needs to be determined. That apart, no document is produced either before the consolidation authorities or before this court by virtue of which Buddhan Samiti asserted to have acquired title over the lands in question. The order sheet reveals that consolidation authorities called for such documents, but the same was not produced by the opposite parties, and with an erroneous presumption, the appeal revision were disposed of without drawing an adverse interference. Admittedly, after vesting, the lands had been settled in favor of the petitioner. Here is my case also, it is the same thing, my lord. Admittedly, after vesting, the lands have been settled in favor of the petitioner under OA Act, and the record of rights were prepared in his favor. The order settling the land in favor of the petitioner under OA Act has not been challenged by the opposite parties, and the same has attained finality. The order being a valid one, under the provisions of the Orissa Consolidation Holding and Prevention of Fragmentation of Land Act, the consolidation authorities are bound to the said order. Law is well settled that authorities cannot traverse beyond the order passed by any of the authorities under any of the state laws. This aspect of the law not being kept in mind by the commissioner, that apart, after vesting of the estates, none of the intermediaries had any right, title, or interest to donate any portion of the intermediary estate in favor of Buddhan Samiti. Admittedly, after vesting, the state became the paramount owner and the intermediary lost all its rights, and any of the documents said to have been executed by any of the co-sharers were ab initio void. It is stated that no documents were produced before the consolidated authority. Here, my lord, in my case, consolidated authorities have considered all the documents because I had, during that consolidation proceeding, my lord, I had submitted all the documents, they were field verification, and the consolidation RO was also published. All right. After that, my lord, all these developments have happened. My lord. That was also within the knowledge of the OA revision case, my lord. In the OA revision case.
All right. Who's for the other side?
For private respondents, Mr. Mukherjee is appearing.
No.
I am for the state. Only thing I want to submit before your lordship, that the factual finding of all the courts below is that he is not in physical possession of the land, because the cardinal principle of law under section 6 and 7 of the OE Act, no settlement can be drawn in favor of a person who is not in physical possession of the land. And there is a categorical finding that he is not in possession, and that has been transferred to somebody else. So in Article 2, in a writ jurisdiction, whether those finding of possession, factual findings can be interfered with, that is first question your lordship is to examine. The next is, your lordship may kindly see the last para of the impugned order. The Honorable Supreme Court in so and so held that the nature and character of the land being non-agricultural, the same evidently was not in cultivating possession of the intermediaries, and thus an application for settlement of such land by the intermediaries purported to be in terms of section 7 of the Act was not maintainable. The land being Anavadi in status with Kisam Podia as per 1928 ROR. So in the present case, the petitioner not in khas possession of the case land and not entitled to the benefits under section 6-7 of the, as a result, the division is disallowed. So even the Kisam of the land is Anavadi and Podia. So it is not agricultural land. So he can claim that I was under the intermediary, I was in physical possession, cultivable possession of the same. And these are the factual findings. Inter se between two private parties, this litigation was fought before the lower courts. And now I support the order of the revisional authority on the ground that there is no error in it, because factually he could not establish a case of possession over the land in question.
Right. My lord, due respect, my lord, the rent receipt that has been asked to
that is neither here nor there. You may be paying rent, but you may not be occupying it.
And so far as the ROR that my lord is saying, that is of the 1928, my lord.
Yes.
Consolidation proceeding has been completed in the year 1977, my lord.
All right. We're not inclined to interface. Dismiss the detailed order will be passed.
So far as this appeal is concerned, that the title appeal, the second appeal has been dismissed, my lord. And my position has been confirming that, my lord. Permanent decision was granted, my lord.
It's all right. We'll deal with all.
We kill list item number 3. Item number 3. Weekly list item number 4.
May I please, my lords? In this writ application, my lord, the petitioner very limited prayer, my lords. My lord, fact of the case is like this, my lord. Opposite party number, my lord, 1 and 2, my lord, made an auction, my lord, advertisement for auction of a minibus, for which is issued tender, my lord. No, my lord. In this process, tender process, petitioner participated by depositing of rupees 40,000, my lords. Subsequently, the tender process was over, my lord. The petitioner could not successful in that tender, my lord. I am only limited prayer, my lord. The 40,000 which are deposited before him, my lord, the same amount may be returned to the
It
petitioner.
must be forfeited. There's a forfeiture clause.
Pardon, my lord. It is a false case, my lord.
False
Because
case.
kindly see that if he had ever deposited that amount, my lord, he should have filed the receipt, my lord, acknowledgement receipt, my lord. There is no acknowledgement receipt first, my lord. Then, my lord, kindly see that the auction proceeding is of the year 2001, my lord. What prevented her to file immediately thereafter
You say the
to get
auction,
his auction
prayer
money,
in the
my lord?
present petition is limited to
And,
seeking refund.
second, the third-
1 minute, madam. Prayer in the present petition is limited to seeking a refund of rupees 40,000 purportedly paid by the petitioner at the time of an auction held in 2001 for sale of a vehicle by the Orissa State Financial Corporation. There is no explanation why the petitioner waited for 8 years, for 7 years after that, to file the present petition. Moreover, there is a dispute raised in the reply filed whether in fact he participated
Not
in the auction or deposited the sum of rupees 40,000. That view of the matter, the relief as prayed for cannot be granted with this court. The petition is dismissed.
Direction may be given if, my lord, the 40,000 is pending before they may be released, my lord.
Sorry.
We have dismissed the petition, sir. All right.
Weekly list item number 5.
Official lordship on the auction, my lord. No instruction, my lord, on.
No instruction disposed of.
No instruction. Weekly list item number 6.
None appears dismissed and not prosecution.
Weekly list item number 7.
None appears.
Even, my lord, I'm there, my lord.
Yes.
My lord, the paper book is seen, my lord, misplaced.
No paper books have been prepared despite pendency of the present petition for 14 years. Accordingly, the petition is disposed of.
Weekly list item number 8.
In item number 8, I am asking for the petitioner. Kindly come to page 24 of the prayer of the in the petition. In the page 24, my lord.
Yes.
It is in the circumstance, it is therefore prayed that this honorable court may be pleased to direct the Selsta Tribunal, Orissa Cuttack, to state the cases and refer the question of law raised herein at paragraph 11 to this honorable court for its opinion and adjudication. Next come to the order number 2, dated 12/3/97. Order number 2, dated would direct this Orissa Selsta Tribunal, in short the tribunal, to refer the following questions along with the statement of facts. That means the prayer, my prayer has been allowed in the year 1997.
Right.
So nothing remains, I think, in this.
All right. By the order dated 12/3/1997, the prayer of the present petitioner has been granted. Nothing survives the present petition. It is disposed of.
Weekly list item number 9.
The tax effect is 87,000.
All right. In view of the insignificant tax amount, the question of law is left open and the petition is disposed.
Weekly list item number 10.
Yes, item number 10 in both the matter, lordship, kindly take up minutes STRB 222 of 2008 first minute. 223 minutes. 223 of 2008 first.
Yes.
Both the matters your lordship admitted and as per interim direction, minutes payment has been made. Minutes questions your lordship will find minutes at page 14. It starts from your lordship will kindly see page 14 minutes. Page 14. Whether in the facts and circumstances of the case, the petition is to be absolved from charge of suppression when in a judicial proceeding under section 21 of the OST Act, the transport company denies of having delivered any such alleged consignment to the petitioner. There's two questions may be sufficient. Whether in the facts of the case, any infirmity as to status and non-production of evidence on the part of the representative of the transporter in the statutory judicial proceeding under section 28 read with section 1280 of the OST Act led to presumption of purchase suppression by the petitioner. Yes, others may not be so much relevant, others are consequential. What has happened, let me tell my lords, what has happened, based on the third-party accounts, namely the transporter, allegation of suppression are raised against the petitioner. Petitioner, while producing books of account to assessing officer, said that the charges are spurious. He has not received any such consignment as alleged by the officer concerned based on the deposition of the transporter manager of the transporting company. And I prayed for summoning under section 21 to summon the concerned person. Whereas on being summoned, the transporter appeared through one Sashi Raut. The Lordship may kindly see the first appeal order at page 32 minutes. Page 32.
Yes.
Plus, your Lordship may kindly see 10 lines below. Accordingly, the transporter.
Yes.
Accordingly, the transporter in the instant he is summoned under section 21 of the OST Act by the law and STO, but instead of the manager of the transporter, one Nityananda Raut, said to be emissary, working on the said transport since 91, as marketing assistant, appeared along with the appellant and the learned advocate. On confrontation, Raut stated that the appellant Lakshmi Trading Company has not received any goods on dates mentioned in the report in the code name Lakshmi DS from their transport. This apart, he has also stated that Devadas Chakravarti, who furnished the statement in this case, was not an employee of that organization. In support of his contention, Mr. Raut could not produce any supporting books of account to prove that no such goods were delivered to the appellant as alleged in the report by the manager of transport. Further, and queried by the STO, he could not produce an authorization letter from the chief in charge of transport organization that he is authorized to give such statement on behalf of the transporter. Your denial of fact by self and emissaries without adducing sufficient evidence can only be treated as a ploy adopted to keep the subversive activities out of clutches of the sales tax. Acquisition of the advocate that the law and STO has not afforded sufficient opportunity to apparent before passing the order of assessment is never excuse failure of self and evident from the fact. Now, my lords, what falls from this is the person who appeared, my lords, he said that we have not, transport company has not delivered any such to the petitioner concerned, but he failed to produce authorization, valid authorization according to the officer in his favor. And he one vital submission which he made, where the statement of the manager, based on which this assessment was made, the Devadas Chakravarti, he said that he is not an employee of the company. Therefore, before the first order authority, while annexed to your Lordship may kindly see, at page 25 for a moment, I have filed an application under section 21. That is to issue summon to Devadas Chakravarti, the person based on whose original statement the proceeding was initiated. Page 25, my lords, for a moment. To the Assistant Commissioner, appeal number 1, so petitioner for extending opportunity confrontation with Devadas Chakravarti. Last paragraph. In the circumstance stated above, it is prayed that the above-named person, Devadas Chakravarti, or the branch manager of the transporting company may kindly be summoned for confirmation with their books of accounts and delivery register to ascertain genuineness of the transaction. The appellant is prepared to bear the cost of confirmation of this. But despite of such a application being filed under section 21, no steps are taken to call the manager, and your Lordship, two judgments I refer to of our High Court, one High Court, in Ferro Alliance Corporation's case, your Lordship said, I am sharing with your Lordship.
What is the total tax demand, sir?
Total tax demand 66,560 millions for in 223 millions. And other one is. And your Lordship directed to pay 30,000 as an interim direction. I have complied with that, your Lordship's order.
Yes, who's Mr. Padi? Now that he has paid half the amount, why don't we close the matter? Because now sending it back for him to summon the transporter, all that is impractical.
Yes.
You see, one of the grounds on which the impugned orders have been challenged is whether the petitioner's application for summoning the transporter to prove the factum of suppression of purchases ought to have been allowed by the authorities. Question mark. Paragraph. The matter relates to the year
91,
92,
91, 92.
and 93, 94. Full stop. At this stage, to require the transporter to be summoned for being examined in the assessment proceedings is impractical. Full stop. Consequently, for the further fact is that by interim orders passed by this court on 9th May 2008, the petitioner was asked to deposit 50% of the tax demand, subject to which no coercive steps were to be taken against the petitioner. So, admittedly, the petitioner has complied with the said interim orders. So, in other words, 50% of the tax demand has already been paid. Paragraph. Keeping in view all of the above factors, the court directs that the amounts already paid by the petitioner should be treated as final payment of all the tax demands for the relevant years 91, 92, and 93, 94. With no further demand being raised against the petitioners for the said years. Full stop. The petitions are disposed of in the above terms, leaving the questions open for decision in some other appropriate case.
I think it is 30,000 instead of 50%. Your lordship can say. I think.
All right, 30,000 in one case and 80 in the other.
3,000 in the other.
All right.
Alert message stated to have been paid because no receipt has been served on us or not on.
Subject to verification.
And 8,000 in the other. All right.
It is stated to have been paid because.
All right. It's
subject to verification. Your lordship.
All right. All right.
Weekly list item number 12.
Well, my lord, the tax effect is 20,000.
In view of the insignificant tax effect, the questions of law and the revision petition is disposed of.
Weekly list item 13.
Here, my lord, 72,000.
All right. In view of the insignificant tax effect. Okay. Same.
Weekly list item 14.
This 1,600.
Days delay. The delay of 100,600 days delay has been not satisfactory.
Here, my lord, the tax effect is 1,600.
Oh. In view of the insignificant tax effect, the question of law is left open and the petition is disposed of.
Weekly list item number 15.
Here, my lord, it's 5,000.
Huge tax effect filed by the state. 5,487.
Right. In view of the insignificant tax
all the questions have been answered by this honorable court. Covered case.
All right.
I am giving the judgments, my lord. Lordship may kindly peruse the judgments because the already the questions, all the questions raised by the state has been answered by this honorable court.
Tribunal's order has gone in favor of my learned senior. Now it is that the tribunal order has gone in favor of my learned senior. Now if our question is dismissed, I don't think my learned senior.
Already, no. Already the questions have been answered in favor of the dealer. That is what I am submitting before this honorable court.
All right. The tax effect is insignificant. Moreover, it is pointed out that the questions urged by the petitioner stand covered against the state, against the department, and in favor of the SSC by the decision of this court in state of Orissa versus Habib Rahimullah and company.
51 STC 403.
51 STC 403 bracket Orissa and Hari Bhagat Agarwala versus state of Orissa. 51 STC 355 Orissa. All right.
Oblate.
The petition is accordingly disposed of.
Weekly list item number 16.
Here it's 7,874.
In view of the insignificant tax, the question of law is left open and the petition is disposed of.
Weekly list item number 17.
None appears disposed, not possible.
Weekly list item number 18.
It's 66,000.
In view of the insignificant tax.
Weekly list item number 19.
Delay is how much, sir, here?
365 days, more than 365.
delays more than 65 days, which is not properly explained. The petition is accordingly dismissed on the ground of delay.
Weekly list item number 20.
None appears. Dismissed.
My lord, it has been complied with. I am in the virtual court. I am for the university. By the order dated 8/10/2015, the orders have been complied with.
Moreover, counsel for the university states that the orders have already been complied with. All right. The petition is disposed of.
My name may kindly be recorded. Also,
all right, sir. All right, sir. All right.
Weekly list item 21. Item number 21.
None appears. Dismissed.
Weekly list item number 22.
22, my lords, I am for the opposite party. The petition is dead.
Okay. Counsel, the petitioner points out that the petition has expired.
He died on 13th July 2016. I have a death certificate.
Oh, you're for the opposite party.
I am for the Bhubaneswar
Counsel for the
Municipal
opposite
Corporation.
party points out that the opposite party is expired. None appears for the petitioner. The petition is dismissed. All right.
Weekly list item 23.
None appears. Dismissed.
Weekly list item 24.
None appears. Dismissed.
Weekly list item number 25.
21 minutes.
25, sir.
25 and 26, I am for the opposite party. Orders have been complied.
25. Counsel, the opposite party states that the order has been complied with. None appears to the petitioner. It's dismissed.
Weekly list item number 26.
None appears. Dismissed. Not prosecution.
Weekly list item number 27.
Item 27, my lord, the order has not yet been complied with. Your lordship may kindly see the order dated 16/4/2010, where my lord has been pleased to direct the authorities to supply the certified copy of the documents as prayed for. Till date, my lord, the same has not yet been complied with.
Who's for the other side? Has notice gone, sir, in this?
No. Yes, my lord, notice has gone.
27 is Mr. Chinmoy Kumar Acharya. My lord, this is 2474.
The order is 10th November 2014.
I think the contempt note is to be noticed.
No, but the contempt may not be around, sir. It's a 2010 matter. By an order dated 10th November 2014,
Tahsildar Kodola.
The grievance of the present petitioner was noted, namely that you had not been supplied certified copies with documents applied for in mutation case number 594 of 2004. Mr. D.K. Mohanty at AGA states that he will seek instructions and ensure that the aforementioned documents are provided to the petitioner before the next date. List for compliance on 20th July, 20 July.
Obliged, my lord.
Weekly list item number 28.
Because he may not be available, so I have to get instruction from the present incumbent.
Whatever, sir. And give it to him, sir. If he wants only some certified copies, mutation case.
In this case, there has been a delay of 218 days in filing the appeal against the judgment of single judge.
Which matter, sir?
28.
The unexplained, there's an unexplained delay of 100.
There has been delay of 218 days.
218 days.
In filing the appeal.
Right. Accordingly, the application for condition of delay is dismissed. The appeal is accordingly dismissed.
Weekly list item 29.
29. I pray, my lord, you also may kindly take up. I have lost the file. I had taken the Xerox copy for the file from my friend, my lord. I pray, my lord, can it be taken up next week only?
What's the matter about, sir?
This is a matter, my lord. It has come back twice from Supreme Court. It is with regard to reference, my lord. The only question is to whether the Supreme Court has said that the reference has to be done in 25N, my lord. But they have the labor court. They have he has decided that it will not be 25N. It will be 25O. So that is the, and they have got the single judge and now the writ appeal. So I only pray on next week. This much of file, but I have taken the help of my friend. I got the Xerox copy from my friend, my lord. Any day next week, my lord, only Monday, Tuesday, up to Wednesday, any day, Thursday or Friday, any day next week, my lord.
No, an extra copy. My lord, I am for the opposite party in this case, my lord. And my name may be recorded for my appearance, and no copy has been served on me, my lord.
Who are you for, sir?
I am for the respondent, my lord.
No, which matter are you appearing in?
Item 29.
What is it?
Maybe.
We are calling out 28, I thought.
No, Union of India.
29.
Union of India.
How? Is it writ appeal 574?
Yes,
Madam,
my lord.
Writ appeal 574.
There is no copy, my lord. I have
No.
Union of India. Union of India.
She's appearing for Union of India.
Yes, my lord.
And you're for the appellant.
Madam.
Counsel for the appellant will serve a copy of the paper book on Counsel for the Union of India within 1 week. It's on 19 July.
Weekly list item number 30.
Next week.
19th July. 19th July. Item 30, sir.
Item 30, my lords. I received counter matters on 25/2022. My lords can be disposed of also. There is a market yard, my lords. Local market that's called Hart. Now, government proposed to undertake a construction of a market yard, my lords, house, my lords, in the year 2007 and 8. 5 lakhs rupees was spent. It could not be completed, left abandoned. Thereafter, adjoining to that, another market complex. I have come up before the Honorable High Court matters to complete this and also allow to utilize it. But I got that counter mailers on 2/5/2022. Also, that refers to the counter dated 26/7/2011 mailers. This says that we have the fund, there is a crunch of fund. We have requested the government and other authorities to allocate the fund and to complete it. What is happening was 2007, now we are in 2022 mailers. What has happened in the meanwhile, I have not taken instruction, just counter I received on 2/5/2020 at 4 p.m.
All right. You say, due to passage of time, clearly the matters would have become infructuous. If any cause of action survives, it will be open to the petitioner to file a fresh petition. The petition is disposed of.
Weekly list item 31.
None appeals. This was not.
Weekly list item 32.
31.
31. Yes, sir. Yes.
My lord, there is a noting, your lordship, that receipt showing deposit not made. I had filed it 25/7/2018. If it is not in record, I am giving a copy, your lordship. This relates to, your lordship, an order passed by my lord.
District Consumer Disputes Forum.
Forum, my lord. Where the assessment has been made by the, your lordship, the surveyor is 1,92,000. That your lordship would find that.
But against the district forum, you can go to the state forum.
State forum I went. Unfortunately, I was late. So, my lord dismissed for.
But what you challenge here is the district forum's order, not the state forums.
State forum rejected my petition.
That's
rejected
right.
my appeal. And so also this revision. Your lordship may kindly look at the order, your lordship. Looking at that only, my lords have passed that interim order. Page 39, your lordship, of the brief. 1,92,500. Relying on this, your lordship directed me to deposit this amount along with interest and 20,000 rupees cost.
That has been received by the complainant now.
That has been received by the complainant now.
This
We
was
back in
received.
2011 itself. That is what the order says.
So why leave the question open, sir? Why do you want this money back?
I don't want the money back, your lordship. I mean, DCDRF says I am to pay 6,15,000.
Who's for the other side? Have you served the other side, sir?
PK Das, on Mr. PK Das appears. It seems he has filed a counter also, but copy not served. For OP2. Ramesh Chandra Swai is the.
So we can condone the delay in filing the appeal before the state and send it back there, state forum. Which is the order of the state forum? Where is the order of the state forum?
Oh, that is at page 29, my lord. And so also the revision petition is rejected at that is at page 20.
Two years. All right. For the reasons stated in the petition, and since the interim order passed with this conditional interim order passed this court has been complied with by the present petitioner, and the amount deposited by it, the sum of rupees 261,833, has been received by the complainant, the court condones the delay in filing first appeal number 475/2010 before the state forum. Full stop. Accordingly, the order dated 23rd November 2010 of the state forum is hereby set aside, and first appeal number 475/2010 is restored to the file of the State Consumer Dispute Redressal Commission for being proceeded with in accordance with law. The petition is disposed.
Your Lordship may also consider restoring my RP 62. Because
Sorry?
he had initiated the proceeding, my lord, under the for realization of the amount, he had taken coercive steps, execution. As against that, I had come, that again was dismissed for delay, my lord.
Which is that order?
Page 51, your lordship. Page 52 is the operating question. Ground of limitation at the admission stage.
Correspondingly, the order dated 24 January 2011, passed by the State Forum, in revision petition 62 of 2010 is set aside, and revision petition 62 of 2010 is also restored to the file of the State Forum for being proceeded with the cause of law. Both the aforementioned first appeal and revision petition will be listed for direction before the State Forum on 4 July 2022. All right.
List item 32.
May I please? Here, initially the opposite party workman approached the Land State Administrative Tribunal for regulation of service. That relief was not granted. And thereafter, that OA was disposed of with certain observations. And thereafter, since that order was not complied due to financial constraints, he filed a contempt petition that was also rejected. And after failure in 2 occasions, now he approached the Land Industrial Tribunal and the relief has been granted. Your Lordship, State kindly turn to running page 40, annexure 7.
What is his age, sir? And what is the amount?
No, direction was for reinstatement in service along with back
So
wages.
what is his age? What is his age now?
Age is 48 years. 47 plus 48 years.
Where do you get it?
Well, he has filed the
Counter affidavit.
He has filed the
He was
17
41 years in 2011, sir.
So in 2014, he has filed the miscase for compliance of 17B. There he has stated that 41 years in the year 2014. That my lords can get it miscase number 21515 of 2014.
But nobody's appearing today, sir.
My lord, may kindly state it on to running page 40, annexure 7.
Who's the name of the lawyer?
Mr. R.K. Sahu.
R.K. Sahu.
Yes.
Notice of that process will be issued to Advocate R.K. Sahu, who appears for the opposite party workmen, to remain present on the next date. This one, 26 July.
Weekly list item 33.
My lord, this PIL has been filed for direction to the opposite party for construction of a drain, as there was a waterlogging problem. But it has been solved. They have constructed an alternative drain.
Reflex of time. The petition has been rendered infructuous and it's disposed of. Right.
Quick list item 34.
I am appealing for opposite part number 4, my lords.
None appears dismissed in opposition. All these matters.
30, lords, item 33, I am appealing for opposite part number 4.
All right, sir.
Item 34, I am appealing for opposite part number 3. 2, sir, 2 minutes.
All right. Weekly list item 30.
Second matter, I am appealing for opposite part number 1. Second
All right.
matter.
All right.
6949.
All right, sir.
Weekly list item 35.
None appears dismissed in opposition.
Weekly list item 36.
May I please, your lordship?
Yes.
Your my lord, it is challenging the hour. The petitioner has came up in the writ application. Here, my lord, reinstatement with 50% backwages was the order. That quantum I have challenged. Of course, it is a matter of 2011.
Correct. Sir.
And now I am 65 years of old.
Correct.
So if something can be enhanced so far,
How many years did you serve?
I'm 65 years.
No. How many years did you serve?
My lord, I am since 86 to 93, my lord.
So that time, that 50,000 was reasonable, sir. You said
That
the
was
petition has been
50%.
filed only to seek enhancement of
Reinstatement
the
with 50%.
compensation amount
50,000.
of 50,000 rupees. Having heard learned counsel for the petitioner, the court is not inclined to enhance the amount any further. Petition is accordingly dismissed.
Yes. Weekly list item 37.
May I please, item number 37. Here I am challenging the order passed by the Endowment Commission order annexed 10 millions. My ground of challenge is that, my lord, this particular land is recorded in my name. I have annexed the ROR that was published in 1996 and settlement ROR. In fact, that land was settled, if your lordship will come to annexure 5, that is on dated 5/5/1975. This land was settled in my name, lords. By the in OEA case number 83/75. At page 16, annexure 5.
Were you heard by the commissioner?
My lord. Well, I was heard. I filed the objection because they have no right title interest. That is why they have filed a suit also. That is also pending. That suit is annexure 8 minutes. To declare their right title interest, that is annexure 8 minutes. So therefore, they have no authority to initiate that proceeding under section 25 minutes.
Yes, Mr. Monty.
Mr. Lord
Mahanti
Lingaraj
is for
Mahaprabhu.
state, huh?
I am for this state, but it is a case where the counsel for Lingaraj Mahaprabhu is to appear and answer. Who is appearing?
Notice was issued on 25th of July, 2011.
Your Lordship may kindly check that whether the notice as against the DT is sufficient or not. That is because DT is to contest. This is a 25 proceeding.
And 2 is the DT.
But have they been served? Served. Yeah, he's been served. He's been served. The date he's been served.
It is already served.
Let it go back to the commissioner, sir.
Yes, madam.
That is why, milords, I am saying, milords, this 25 proceeding is not maintainable. My submission is that.
Let them decide that, sir. Despite service of notice, none appears for opposite party number 2. Counsel for the petitioner states that the short ground in which challenge has been laid to the order dated 26th October 2010 passed by the Commissioner of Endowments in OA number 131 of 1999 is that the petitioners are in fact sorry, owners of the suit land and the ROR finally published in 1995 bears this. He states that out of 3 plots, plot numbers 3059 and 3017/3891 are subject matter of dispute, which was the subject matter of the dispute in OA number 131 of 1999, initiated under Section 25 of the OHRE Act. They claim to have been issued a settlement patta in 1995 and are staying by constructing a residential house after obtaining permission from the Bhubaneswar Development Authority. It is also stated that a civil suit being PS number 357 of 1999 has been filed with the Court of the Civil Judge Junior Division by opposite party number 2, that is the deity, claiming right title and interest over the land in question, and full stop. It is stated that the said suit is still pending. Paragraph: the above facts do not appear to have been taken note of by the Commissioner while passing the impugned order dated 26/10/2010. So on that short ground, the impugned order is hereby set aside, and OA number 131 of 1999 is restored to the file of the Commissioner of Endowments, Orissa, for being proceeded with afresh in accordance with law. The matter will be listed before the Commissioner of Endowments on 11th July 2022 for directions.
Item number 21 I was held up in another court. It was dismissed for default.
Tell us what is it about.
Yes, there is a contempt application. There I objection to the compliance affidavit. I have already solved copy of the.
No, you are for the petitioner or for opposite party?
I am for the petition contempt application. I filed copy of the objection to the compliance affidavit. Actually, there is no issue. They have already complied. They have given an affidavit. But my only objection is that in their compliance affidavit, they have stated that my service is 33 years, 2 months, 15 days. But in actuality, by disbursing authority, they are mentioned, which I have filed affidavit, that it is only 12, that is annexure 6 at page 4, that is 12.5 years. This much is the disbursement. You will also may grant leave. I will approach the Central Administrative Tribunal for dispute computation of that period.
Paragraph: counsel of the petitioner states that although there is substantial compliance with the directions of this court, in the computation of the qualifying service, there is a discrepancy. He, however, states that in this regard, he will separately approach the authorities for appropriate relief.
Deeply.
The petition is accordingly disposed of.
Weekly list item 38.
38 will accept no instruction.
No instructions dismissed. The memo is taken on record. Petition is dismissed in terms thereof.
Weekly list item number 40.
Please, your lordship.
But my lord, here I am for the opposite party workmen.
Here, my lord, in the meantime, my lord, the petitioner establishment has been closed down in the year 2014, my lord. And till closure, my lord, the last wages drawn section 17B compliance has been made, my lord. In October 2014, the unit has been closed down, established.
All right. Counsel of the petitioner points out that since 2014, the petition unit has remained closed. That view of the matter, the petition has been rendered infructuous. And
My lord, that award was passed in my favor. That is reinstatement.
Now you reinforce it, sir. For what it's worth.
My lord, so far the other party is concerned financial benefit because 50,000.
So you have to enforce the award now. You have to enforce it.
It is if at all they are saying closed. So other part they should comply, my lord. Because
no,
so
that's it. But this is not an execution proceeding, sir. This is only a challenge. Yes.
Weekly list item 41.
41, my lord.
No instruction in this matter, my lord. No instruction in
No
this.
instructions disposed of.
Weekly list item 42.
None appears dismissed on opposition.
Weekly list item 43.
43, no instruction, my lord.
No instructions disposed of.
I am for the opposite party, my lord.
I'm for 42 lordship, I'm permitted to withdraw lordship.
42.
My lord.
Council petitions
Council
to withdraw the second.
Filing letter application.
43.
No instruction, I have said.
Say.
I am for the opposite party, or lordship.
Weekly list item 44.
None appears dismissed on opposition.
Weekly list item 45.
45, my lord. All the contents are identical matter, my lord. Regarding disposal, which is a disposal of the content number 412 of 2010. That is a noting in there, my lord. In the light of this contempt, all the contempt dispose of.
All right. Council to petitioner states that nothing survives in these contempt petitions. They are disposed of as such.
Weekly list item 46.
None appears dismissed on opposition.
Weekly list for orders item 47.
None appears dismissed on opposition. That MC case.
Weekly list item 48.
Again, MC case disposed of. Dismissed on opposition.
Weekly list item 49.
Item 49, my lord, I am for the petition. My writ appeal has been dismissed. But one miscase has been filed by perhaps my learned senior friend has filed and
In this
miscase.
judgment, my lord, my name was not there. That's why, my lord, I have filed an application. So by flux of time, my lord, is.
All right. Only his name was not there, sir.
Yes, sir. In the judgment.
For the reason stated, the application is allowed. The order be retyped indicating the name of the council as indicated.
Problem.
Weekly list item 50.
Item 50.
The office note has been perused. The order be correctly typed by reflecting the writ appeal number as 592 of 2011.
My lord, may I pray, my miscase 43 of 2015 is pending. Can it be disposed of with regard to substitution of legal height?
All right, 43 2015 for the reason stated there, the application is allowed.
Consolidated copy be served.
All right.
Supplement.
This writ appeal is still pending, item 50.
Pending. Yes, it's pending.
Then tell us what is it about?
This is regarding. In fact, before my learned senior, this is not maintainable because the honorable single judge exercise the jurisdiction under Article 227.
The scope is limited for so far as read court is concerned. That is well settled since 1964. That constitutional bench judgment AR 64 Supreme Court 477, where it was held that read court normally should not reassess the evidence on record.
This writ appeal is not maintainable, sir. You have to file an SLP.
No, my lord,
So considering that the single judge exercise jurisdiction under Article 227 of the Constitution,
my lord,
the
so
present
far-
writ appeal is not maintainable and it is dismissed as such.
My lord,
This will not prevent the appellant from seeking other appropriate remedies in accordance with you.
the number of normally we prefer this against the single bench judgment with regard to award or order of the labor court. If
labor court award, when you challenge, it's a 227. It's now coming before division
now
bench.
it has become division bench assignment. Earlier it was single bench assignment.
Correct. Either way, sir, you have to go only under 136 after that. After the High Court deals with it, we can only go in 136.
In fact, in the impugned order, honorable single judge has observed that he is exercising supervisory power.
Correct. All right.
Liberty.
I've given, sir. Right.
Keep level.
Right.
Supplementary list. Supplementary list, fresh admission, item number 1.
Yes.
My lord,
This is a very short case involving the PIL, and I have a very small prayer. My lord, in this case, the petitioners are the elected representatives of the.
Your representation is pending.
My representation is pending.
Where is that?
At Annex 3, my lord.
All right. The petitioner's representations, bracket Annex 3 series, shall be examined by the General Manager.
General Manager, East Coast Railway.
Coast Railway, and after giving the petitioners a hearing,
may make a small prayer, my lord.
a reasoned order shall be passed on the representation not later than 5th September 2022. The order shall be made available to the petitioners not later than 12th September 2022.
My lord, they should not abolish the check gate, my lord.
We don't know about all that. All right.
Oh, bless.
Supplemental list item number 2.
Entry order, my lord.
Item number 2.
My lord, item number 1, my lord, pass the entry order.
Item 1 is disposed of, sir.
Item number 2.
Kindly pass over, my lord, on behalf of.
All right, pass.
Supplemental list item number 3.
Sir, this matter has come up by virtue of order of the Honorable Single Judge, my lord. Since the issues involving the writ is public interest, the matter to be heard.
In fact, you lordship can see paragraph 3 of the writ petition. This is indirectly he challenging the order passed in a GIA case.
Yes, my lord. That has been filed before the Honorable Single Judge, and by virtue of the order of the Honorable Single Judge, the matter has come up before this bench, my lord.
Once you are not a party before the State Education Tribunal, you have no locus to challenge that order.
My lord, what happened? The State Education Tribunal has passed an order to consider the case of this opposite party number 4, who has been given appointment by an illegal appointment order, my lord. By that illegal appointment order, that to be carried out the Honorable.
So the prayer in the writ petition is for the against the order of the Education Tribunal. No, it's a co-warrant.
That
co-warrant, lordship can see paragraph 3.
I have challenged Annexure 1 order, the legality validity of the approval against the opposite party number 4. My lord, let me finish. My lord, may I kindly turn to page 11 at the engagement order, that is for 28/5/91 at page 11. That the engagement order of this opposite party number 4, my lord, that has been reflected in the approval order of appointment at page 11. Date of filling up the post 28/5/91, then date of joining the post in the of the incumbent 28/5/91. My lord, let's turn to the qualification of this.
When are you filing, sir? This 1991 appointment, you're coming in the year 2022-21. What is this? After 30 years, you're challenging?
No, my lord, not at 30 years, my lord. The tribunal's order was passed in
1 was issued in the year 2012.
The approval order in 2012, my lord.
Then you're coming after 9 years. You can't come whenever you feel like, sir.
He has been set up by some rival person.
You say there's an inordinate delay of 9 years in questioning the appointment of opposite party number 4, which was made way back in 2011, 2012. With the delay not being explained satisfactorily, the court is not inclined to entertain the present petition.
Madam, my representation may be considered by the commissioner, that is at page 19, my lord.
No,
because some illegality is committed.
All in good time, sir.
Honorable Apex Court in the state of Orissa versus Mamta Mahanti has held that if an
everything has to be done in good time. Yes.
Appointment is bad in the very inception, that the subsequent development cannot sustain, my lord. That is the Honorable Apex Court order, my lord.
All right.
So, my lord, let my representation be considered, my lord.
No, sir.
In by virtue of the Mamta Mahanti.
Item number 4.
No, sir, we're not inclined. Yes.
Item number 4.
My lord, permitted to withdraw, my lord.
Counsel, the petition seeks leave to withdraw this petition, dismisses withdraw. All right.
Supplemental list item number 5.
My lord, 1 is time to remove the defect, my lord.
Defects be removed within a week, rest thereafter.
Supplemental list item number 6.
For a week's time to remove the defects.
All right. Defects be removed within a week, rest thereafter.
I may look to the record, the defect to know.
Yes.
Supplemental list item number 7.
Item 7, my lord, 1 week time to remove the defects.
All right. Defects be removed within a week. Rest thereafter.
Supplemental list item number 8.
One time is given to remove the defect be removed within a week list thereafter.
Supplementary list for admission, item number 9.
Item 9, last occasion, my lord, directed to find out the whereabouts of the opposite party number 1. Though I have received the letters, I received an intimation that he is serving in the district education officer. Then I have to take further instruction from the district education officer. And I have to also serve the notice on her.
It's a 2009 matter, sir. Why have you
Here, my
persisted
lord,
with it?
the tribunal has directed, my lord, initially, now the tribunal has directed to create a post and give appointment to the applicant. The post was advertised for a male candidate. My lord, against that, she claimed for appointment. And by virtue of interim order, she continued for a.
No, where is she? She's still serving.
Yes.
Now, has she been served in this present petition?
Yes, it was, notice was issued, but the AD is not back on the OP number 1 and 2.
That's right. Without service of petition on her, how could we proceed in the matter, sir?
So he's serving in the school, man.
So you have to serve the
Yes,
petition
sir.
on her, sir.
I have obtained the instruction that he is serving under the district education officer. So I have to take instruction from him and serve the copy, the notice also.
Mr. Mudali states that he will serve a copy of the petition on opposite party number 1 at her present place of service. List on 21st July.
Supplementary list, item number 10.
Item number 10, my lord.
May I, my lord, in this case, my lord, one Dukhu Mirdha, a piece of land was allotted in favor of him, along with the 3 family members. Thereafter, my lord, after the allotment of the government land in his name, then one company was grabbed his land. He tried to use level west, but he not capable to restore his land. And he approached before the administrative, before collector and everything. When he harassed in all aspect, he has written a letter to the President of India. Thereafter, my lord, then my lord, it was published in the Dharitri in the 16th June 2012 that if there is no meaning to live, though everything is grabbed, I have no rights to live. For that, I pray for the end of my life. This is the fact of the case. Due to the illegality, it is the negligence and inaction of the revenue authority is absolute, my lord. He approached.
1 minute, sir. Do you know if this person is still around? The one who is aggrieved?
My lord.
Whether the person is still alive around?
No, my lord, this matter is assigned by the legal aid service. Only the 2 to 3 documents.
Kindly find out whether he is alive.
Yes.
Counsel for the petitioner states that he will first ascertain whether the person on whose behalf the present petition has been registered. He ascertain the current status of the person on behalf of whom for whom the present petition has been registered. That is request list on 27 July.
Supplementary list, item number 11.
I would require a little time in this matter. This is a virus has been challenged.
All right, at the request of counsel, the petitioner list on 30th August.
Supplementary list, item number 13.
12.
Item number 13, sir.
May I please, your lordship? Now, item 13, my lord. Your lordship may turn to page 56 of Annex 10. The law department has promulgated that Orissa District Subordinate Courts Non-Judicial Staff Services, Methods of Recruitment and Conditions of the Service Rules 2008 below. At page 57, my lord, your lordship may kindly see the cadre. The cadre in the column number 4, it has stated that the Group D employees in each district shall constitute an independent cadre consisting of orderly peon, office peon, sweeper, process server. Now the present is a process server. Night watchman comes sweeper, Malkhana guard and Malkhana peon. In column number 5 is the most important, my lord. The post in the cadre shall be grouped on A, B, C, D in accordance with the provisions of the GA department resolution number so and so dated 7/6/2019, 1999 as modified from time to time. May I appeal my lord to kindly see the GA department notification under annexure 8 at page 45, my lord, where the GA department has clarified for the post of government office says in group A, B, C, and D, where the specific stands for group C is all post in the pay scale, the maximum which is more than 3,450 to less than 9,000 is coming under the group C. And subsequently, government of Orissa, my lord, in 2013 published another resolution that is as page 40 at annexure 4, my lord, where group C is pay band 1800 in scale of pay. Now, my lord, the pay band 1 is 5,200 to 20,200. All the process servers of the states, my lord, they are getting the pay band of rupees 1800 and the pay band of rupees 5,200 to 20,200 in a stretch. And the government, also the SETI Commission's report, my lord, your lordship, Honorable SETI Commission has clarified in annexure 2 at page 36 regarding the revision scale of pay, that is at page 36, column number 3. Honorable Justice has said that the existing scale of pay 2,500 to 3,200 of the process server salary mean of OSPR rule 1998 shall be revised to 2,750 to 4,400. And accordingly, your lordship, the pay revision was made under annexure 3 at page 39, where the pay band 1 at serial number 4, where it has been enhanced to 5,200 to 20,200, coming under the resolution of the state under annexure 4 to be declared as group C cadre. The humble submission and the innocuous prayer that all the process servers, those who are working in the subordinate course and for the service of the notice and other works, can be declared as group C. But your lordship, the impugned order is annexure 7, that is 13/3/2014 at page 44. Page 44, my lord, annexure 7.
Yes.
Full court has, my lord, communicated the same to the only Gajapati at Paralakemundi, stating that with reference to the subject cited, noted above, I am to say that the court, after careful consideration of the matter, been pleased to resolve that the retirement of the superannuation of the process server working in subordinate judiciary of the state will acquire group D employees, and this reason will apply to process server who retired earlier in the decisions of the full court dated 7th January 2014, communicated to on dated 9/1/2014. My lord, so far the retirement is concerned, now there is no grievance because the government has already modified the age of retirement to all that is clarified. But so far the cadre is concerned for group C, because all the process servers whose pay band is now 5,200 to 20,200 as per the OSPR rules 1998 and subsequently 2008 also, that has been modified. And because the counter they have filed, unless it is amended, that rules has already been amended, rule 4, it cannot be. But so far rule 5 is concerned, government has modified and stated that the pay band 1,800 for a salary of rupees 5,200 to 20,200 coming under the cadre of group C. The prayer of the present petitioner and also other connected rate applications, my lord, of the year 2014, the only prayer, the processor be treated as group C on the basis of the salary on 2013 notification, so also 1999 notifications.
These are all matters of policy, I think.
Lord, policy, government has decided the policies.
Yes.
But it is to be rectified in the full courts, because the 2014 notification, that is annexure 47, annexure 7, stated that the group C process server be retired group C. Group D, there is no consequence because all are now retirement age is 60s. For the cadre
So your pay scale anywhere is there. You're not asking for an increased pay, are you?
Scale, no, we are getting the scale of Group C.
Then what does it matter whether you're called Group C or not?
Because they are not, they are treated as on date as Group D cadre.
No, what difference does it make, sir? Your salary is anyway that of Group
Lord,
C.
my salary is protected because of the at par with the Group C cadre, because it has already been changed.
Correct.
So for the retirement, now it is correct, because the retirement age is 60 for all the purposes. So for the cadre strength is concerned, unless it is Group C be declared, then APR and other promotions, other benefits will not be getting that. Then the fact remains, the full court has decided, your lordship may turn to page 43. 43, the joint secretary to government, GA department has clarified, I am directed to invite the reference of your letter number dated 19/9/2013 on the above subject as the GAD resolution number 8/12/1999. All group employees will retire service on superannuation at the age of 60 years, and all other group employees will retire on superannuation after attaining 58. Since the post carrying GP grade pay of 1800 in pay band 1 and GP 1750 in 1 scale be clarified to Group C. When the government has written that to clarify the same to the London District Judge Kalahandi and stating that the retirement age of processor for Daftari will be 58. The earlier District Judge Session Judge Nuapada sought for clarification of the same matter, and a copy of the department of 13/10/2013 to send to District Judge Nuapada to enclose herewith. My lord, my grievance is that when the salary structure and also in our own High Court, kindly see the processor as Group C, Annexure 5 as page 42. On dated 9/1/2014, with reference to subject above, I am to say that the court, after careful consideration of the matter, have been pleased to resolve the employee working processor work in subordinate judiciary will be governed by the age of retirement applicable to Group C employees. When the retirement at par with Group C and the salary has taken, but now their cadre has been confined to Group D.
Yes, Mr.
The
Modi.
government has decided the policy in 2013, specifying the cadres. And our also rules 2008 specify in clause 5, the cadre will be decided as per the notification of 1999, subsequent modification of the notifications.
Lordship, can you turn to the prayer at page 16?
Yes.
There is no challenge to the validity of the rules.
No.
And now you Lordship can see annexure 10 at page 56. And this is the rule. This is Orissa District and Subordinate Court non-judicial staff services method of recruitment and conditions of service to 2008. The next page, page 57. Rule 3, cadre, sub-rule 4. The group 2 employees in each district shall constitute an independent cadre consisting of so-and-so process server, night watchman, sweeper, Malkhana guard, Malkhana peon, treasury peon, Daftari gardener, attendant and library. This provision has not been challenged. Now, your Lordship, so far as the salary is concerned, the registrar has filed the affidavit.
No, he's getting a Group C salary. He says, why don't you call me Group C? That's all. It's a short point.
To that extent,
What prevents you from calling him Group C is the question.
To that extent, our counter affidavit is silent. I will file further affidavit.
Mr. Mudli states that a further affidavit will be filed to explain why the petitioner's prayer for being declared as single quotes Group C bracket employees should not be acceded to, particularly since they are already drawing the pay scale of a Group C employee. The affidavit will be filed at least 1 week prior to the next date, with an advance copy to counsel of the petitioner, who is permitted to respond thereto before the next date.
Milord.
Just on 30th August, 30 August.
Grateful, Milord.
Supplementary list item number 14.
May I please?
item 14 twice. The time was granted to file counter affidavit. Lordship has the last chance to grant.
In one case out of the group, in double page number 11156 of 20, pleadings are complete, my lord.
Right.
Other matters, they have not filed counter.
Others will not file counter. Lordship has the last chance to grant some time.
As a last chance, reply be filed to such of those petitions where it has not yet been filed, not later than 8 weeks from today. Rejoined thereto before the next day. It's on 5th September.
A little earlier that time. Since one case pleadings are complete, my lord, and they are not getting salary.
It's all right.
Supplementary item 15.
On the last occasion, my lord, on 4/3/2022, and additional government advocate seek time to take instruction on the action taken on Annexure 4, my lord.
Yes, who's for the other side?
Yes, I am for the other side. I have received the report, but I will file it in shape of a counter affidavit.
All right. Mr. Mohanty states that he will file his reply in shape of a counter affidavit within 4 weeks. Rejoined for the next day. Let's go on to 28th June.
My lord, 8th June.
28th.
Supplementary list item 16. 16.
My lord, physically handicapped girl was denied her appointment by the district Cuttack on the pretext that they have classified the post subsequent to merit list, publication of merit list.
Pursuant to last order, I have filed a compliance affidavit.
They have admitted that there is a post.
You got a copy of the affidavit?
Yes, I've got it.
Paragraph 3, my lord, can you see? Got to pass appropriate order. So the validity of select list has also expired, that we have stated also.
Case is pending. How? During the validity period, the case was filed.
No, but it was not against any specified disability. Oh, the recruitment committee reserved it for blindness or low vision.
Yes.
Oh, yes.
The advertisement only it was mentioned as PWD.
No classification.
Subsequently, the recruitment committee specified it. Is it valid, sir? Such a subsequent classification is not valid, no? It is still unfilled.
Well, that vacancy was carried forward.
Carried forward.
But
So it's
vacancy
available.
position also we have stated that as on date in total there exists one vacancy in the post of stenographer grade 3.
So she can be appointed against that, sir? If there is no impediment.
No person could be made available.
No, she is available.
No, at present she is available. But during that period.
No, she applied in the same selection.
No,
I stood first.
She applied, but
and she stood first.
Yes, no. He is hearing impaired. It was categorized.
So what is the percentage of impairment? What is the percentage of impairment? Can you not hear?
45% instead of 35% as I may be.
No. So 45% means can you hear or can you not hear?
Yes, I am hearing it.
No. Do you have a hearing aid?
I am using a machine also.
In judicial work, using this machine.
And how
do you know? You have to try it out.
That is why probably they have not.
No, we don't know. On what basis?
Hearing impairment.
And they are preferring a blind man.
So how does it?
No, not blind.
Yes.
Low blindness or low vision category.
Yes. And
blindness or low vision.
Yes.
So actually, persons with disabilities, this is the issue, sir. Even with the hearing aid, you should be able to employ them.
The nature of duty has also to be.
Correct, correct. If you can reserve it for a low vision blindness, you can as well as, because they're using a hearing aid, you can specify the percentage of disability. When you reserve, you can specify the percentage of disabilities. If you look at the act, there are percentages.
He has to appear for the medical board.
How can?
Then if certificate is given, my lord, a certificate is given in, that is, I am suffering from 45%.
No, recently she has to go in.
My lord, disability certificate has been issued and it is 45%.
Yes.
Page 23. Taking cognizance of it, I was admitted in the category.
And she was allowed to sit for the exam. She was allowed to sit for the exam. She topped the exam. See, you should not have allowed then. If you, according to you, this disability should not qualify at all for stenography, why did you allow the exam to be taken?
It was issued in the year 2006. Now, in the meantime, 15 years.
2019, sir.
What? No, 2006, man.
No, the advertisement is dated.
No, advertisement, but this medical board certificate.
You can ask for a fresh certificate if you want.
Yes.
You can't exclude her from consideration. That's the only problem.
That's my pass appropriate order.
All right. Yeah, subsequently.
My lord, this certificate stands good. 2006.
You see, in the advertisement issued for the post of stenographer grade 3 by the district judge Cuttack, one post was reserved. One post of junior typist was reserved for the person with disability bracket PWD category. Full stop. However, when the advertisement was issued, the said vacancy was not categorized to be reserved against any specific disability. Full stop. The petitioner, who happens to be 45%, who has a 45% hearing disability, sat for the examination and topped the merit list. Full stop. However, she was not appointed. Full stop. After her representations yielded no result, she filed the present petition. Full stop. In response to the notice issued in the present petition, a reply has been filed. A reply was filed stating that the petitioner could not be appointed against the vacancy since it was reserved for single quotes blindness or low vision category. Paragraph. After the petitioner pointed out that this reservation for a specified category was not made in the advertisement itself, an order was passed by this court on 11th April 2022 in the following terms. Pursuant to the above order, an affidavit has been filed by the Registrar of Civil Courts, where in para 3 it is stated as under. Reproduce the whole of para 3. Paragraph. It is obvious that the recruitment committee decided to introduce decided to specify the category after the examination was over, and this was clearly impermissible in law. Full stop. It straightaway excluded persons who had qualified and in fact topped the merit list from consideration. Full stop. This is clearly an arbitrary exercise of power and cannot be sustained in law. Paragraph. As it transpires, the said vacancy remained unfilled and was carried forward. Full stop. Even today, it remains unfilled. Paragraph. Counsel, the petitioner states that the petitioner, having a 45% hearing disability, uses a hearing aid.
Yes.
And can efficiently function as a stenographer. Full stop. Mr. Mudali, however, points out that the medical certificate produced by the petitioner is of 2009 vintage.
2006
vintage. Paragraph. that view to matter, the following directions are issued. 1. The petitioner will undergo a fresh examination by a medical board to be constituted by the Superintendent, SCB Medical College, Cuttack, and a certificate as to the percentage of disability will be issued not later than 15th June 2022. The said certificate will be placed before the recruitment committee, district recruitment committee, Cuttack, for its consideration. It will be open to the committee to interview the petitioner as to her ability to take dictations as a junior typist. She's not a stenographer, she's only a typist.
So she has applied under the both the posts.
Both have qualified. Both posts.
Junior typist as well as stenographer grade 2.
Oh,
grade 3.
Junior typist as well as stenographer grade 3 for which she had applied. 3. If the petitioner is found suitable, she will be given the appointment in either of the posts. To stop this entire exercise be completed not later than 4th July 2022.
My lord, one prayer. My appointment should be made with effect of.
No. Now you're really stretching things too far now.
My lord,
it's all right.
They committed mistake.
That's all right.
I'm no way responsible for it.
That's all right. The petition is disposed of in the above terms.
Supplementary list item 17.
17. And this matter was taken up on 20th April. Matter directed to take instruction on the rejoinder. And I have received the instructions in court today. I'll file a reply.
Mr. Mudali states that he'll file a reply to the rejoinder within 2 weeks. Based on 2nd August.
Supplementary list item number 18.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. Shashwat Acharya. He is in some personal difficulty today.
All right.
In this matter,
the petitioner stated to be in some personal difficulty today.
Your Lordship, in this matter, we seek to file a rejoinder.
Rejoinder to be filed for the next day.
If Your Lordship may please to extend the interim order.
Interim order to continue.
Oblige.
Well, I am appearing on the department.
All right.
Supplementary list item number 19.
May I please, Lordship? Lordship, I have received counter affidavit on 28/4/2022, Lordship.
All right. Rejoinder be filed before the next date. Is there an interim order?
Yes, Lordship.
Interim order to continue. List on 10th August.
Well, I am appearing on the department.
All right.
Supplementary list item number 20.
My lord, state is the petitioner in this review petition. Your lordship may kindly straight go to the order. What has happened, my lord? In the order passed in the writ petition, at page 21 of my review petition, kindly listen. Para 3. If such petition is filed not later than 2nd May 2022, accompanied by an application for condonation of delay, explaining the delay on account of penalty of the present petition, such application will be considered on its own merits. The court clarifies and not express any. We are now concerned. Status quo order passed by this court on 7th March 2011 will continue till such time the Board of Revenue passes an order in the application for interim relief to be filed along with the revision petition by the petitioner, provided it is filed within the time stipulated. So, the status quo order is continuing as per the order of this Honorable Court for an indefinite period. They will file revision petition, file an application for what has happened for this particular property is recorded in the government khata in the consultation. I have filed the record of right.
No. We'll ask that Board of Revenue, if he's filed a stay application, we'll ask them to decide it within a particular time.
That will solve the purpose. If that interim application is filed within 15 days.
You have filed an interim application or not?
I have already filed the revision and along with the interim application. My first objection to the review petition is, your lordship will see from the impugned order itself that petitioners 1 and 2 have died and their LRs were added. they have not implemented those errors. The second objection is the review petition is not maintainable in the absence of all the opposite parties also. Those heads, now there are 35.
I only pray
petitions.
that IA may be targeted.
What
That's all.
else is? How he can
He
ask
is
for
submitting that he
modification
has
of an
already
order
filed an
without including
IA
all?
for interim order for status quo.
That's all. We'll
That
say
is
that
to
that should
target
be
within
decided, sir.
Yes.
I have already filed the
That number may be
revision.
provided.
Yes, I just now give the number. Within time, I have filed OEA revision number 3/22.
All right.
Yes.
Having heard learned counsel the parties, the order dated
The one more difficulty is there, Malad.
8 March 2022 passed by this court in petition civil 17222 of 2006 is modified only to the extent of directing that the application filed by the petitioner, original writ petitioners, along with their revision petition, shall be heard and disposed of by the
For interim relief.
for the member board of revenue.
By the member.
Member board of revenue not later than 8th August 2020.
That is true. Because we are going to the project, we are going to that
Madam, may I submit one thing?
30th of May. Because
30th
Fourth,
of May.
okay, 4th July,
Madam,
not later than 4th July, right?
in that writ petition, I have filed a petition, disposal of writ petition. I have filed a petition for return of the certified copies because now the revision is under defect. The
All
certified
right.
copies.
The certified copies be returned to the original writ petitioner, subject to being substituted with the attested photocopies thereof. Right.
So far as this revision is concerned, along with the revision, I have filed the petition for condonation of delay.
That all is already taken care of. Right.
Supplementary list item number 21.
May kindly see.
22, let Mr. Rai argue, then I will supplement after this is over.
May kindly see Annexure 3 at page 13. A notice under section 148A was issued along with along with an annexure asking me to give my response. Then my lords, annexure 4 at page 15 dated, my lords, on 14 I gave the reply. Lords, you will see the date at page 16. At page 16, the date is 14/3/2022, and I have given the e-response, that acknowledgement at page 17, my lords.
Yes.
Thereafter, my lords, an order was passed under section 148A, capital A, small b, without affording an opportunity of hearing.
That's right. You actually said that's a mandatory requirement.
Yes. Lords, you may kindly see page 20.
Who's at the other side?
Madam, Mr. Chimanka. Then they have filed the counter. Just a minute, Mr. Chimanka, please.
Yes.
Lords, you may kindly see what they have stated in the counter affidavit.
Yes.
I'll just bring to your Lordship's kind attention to para 3.6.
Where is the counter, sir? 1 minute.
Well,
Chimanka, where is? When did you file your counter, Mr. Chimanka?
2nd May.
2nd May. It has not reached us. You don't want to file rejoinder?
no, my lords. It is a
admission.
Telltale that opportunity of hearing has not been afforded. Let them afford an opportunity. My lords, I have to give a counter.
So you give a hearing, sir?
Yes, sufficient opportunity is given.
No, it says hearing. The section says hearing.
And also I have got a judgment of the recent judgment of the Supreme Court.
One more hearing we can be. Sufficient opportunity given in the counter is given.
Opportunity being heard was afforded to the petitioner.
My lords, kindly see, the date is given that on 12/3. And on 12/3, they have issued the notice under section 148A. When they have given the hearing, that is a
no hearing was given, Mr. Chief.
Well, only one opportunity of hearing. And let me,
According to the revenue,
the show cause notice which they have given
is an opportunity to be heard.
That is the opportunity to be heard. That's the treated opportunity to be
Yeah,
heard.
because of the new mechanism,
He is given reply,
I think
my
the
lord.
revenue is bit confused. That is why, my lords, they have not yet been accustomed to the new mechanism under this 148A regime.
And the decision they have referred to the counter of Delhi, Delhi High Court Lords, because that is totally Honorable Delhi High Court that they have not dealt with section 148A(b). The only judgment which they referred that doesn't deal with this provision at all.
I see.
I have given also the judgment of the Supreme Court, my lords, by Justice Chandrachud, very recent judgment.
Yes.
I'll just bring to your lordship's kind attention to paragraph 27 and 72, where, my lords, that is Radha Krishna Industries, AR 84 Supreme Court.
The other matter also no.
Yes, AR 84 Supreme Court, sorry, AR 21 Supreme Court, page 2114.
Yes,
My lords, there the lordship have said regarding that provisional attachment under the Himachal Pradesh GST Act.
64 and 72 paragraph. 64 and 72. These two paragraphs is sufficient.
It starts the principle of law they have enumerated at para 27 at page 63, your lordship will find, and at page 72, para 72, I'm sorry, my lords, para 72, they said that before provisional attachment is given, even though the statute doesn't provide, but it has to be given, because it involves civil consequences. So when you are reopening the assessment with the materials gathered, you have to hear me.
All right.
One more decision also I have referred to in my compilation, that is in connection with the Income Tax Act, my lords, by Honorable Apex Court. In the case of Sahara India, Lucknow versus Commission of Income Tax, I refer to two paragraphs. Paragraph
that is regarding this complexity of accounts, whether this
that may not be relevant.
Complexity.
My lord, in the next case,
In
item
your
number
case also,
22,
you'll have to give us a copy of the counter. We don't have a copy.
Copy of the counter.
my lord, in the next case, item 22.
After lunch, I will give the copy, my lord.
All right. All right. We'll continue after lunch, then we'll dictate it after lunch.
My lord, item 22, my lord, I have
As your
filed
lordship
counter today.
pleases.
In item 22, that is similar to this case, my lord. In my lord, senior Mr. Shah's case, my lord, I have filed counter today, my lord.
All right.
Lordship, in the matter, my lord, they have filed a compilation of the judgments. May I pray, my lord, it may be taken up next week so that we can prepare on this.
No. We'll take it up now after lunch.
Yes,
that's enough.
Much my counter be taken.
Just give us a copy of the counters. All right. 1 minute. 23, 24.
Notice has been issued. 23 and 24.
Supplementary item 23.
Notice has been issued to the opposite party.
They've been served.
It is served. It will be after lunch also.
All right, we'll sit after lunch. All right.
He has given me sweet meat melts.
Item 21.
My Lordship, as I was submitting, Annex 3 was the notice given by the department and explaining me, asking me to give my response. I therefore propose page 13, my lords. You may, to the extent you are required to show cause as to why, in view of the details contained in Annex A, a notice under section
Which
1.
one are you reading, sir? Sorry.
My lords,
8217. Which writ petition number?
8217. Annex 3 at page 13, my lords.
Yes.
Lords, you may kindly see the notice to show cause as to why 148 shall not be issued. And the next page is the information given to me, asking me to give my response. That is at page 14, the annexer attached to that notice to show cause. Then I gave my response under annexer 4, page 15. And there, Lordship will kindly see at page 16, in the prayer portion, the assessee further requests that before any adverse views taken in the above matter, an opportunity of being heard may kindly be allowed. Thereafter, my lords, without hearing me, the department, the opposite party under Annexer 5 at page 19 passed the order, and the order, Lordship will kindly see at page 20. The para 6, the explanation of the assessee is examined along with the documents furnished by it. The issue involved in this case is to examine whether the assessee has actually effected the purchase of material from Midis Steel Limited during the year under consideration. From the information gathered, it is clear that Midis Steel Limited has effected certain bogus/fictitious sale to the assessee so far as to facilitate the latter to claim ITC of GST in the books. During the investigation in the case of Midis Steel Limited, it was also noted that Midis Steel Limited has entered such bogus sales in its books so as to make the transaction a genuine one. Unless the assessee following the same modus operandi does not bring the bogus purchase into its books, neither it would claim ITC on such purchase, nor could it inflate its expenses to suppress the taxable income. The evidence in support of the actual movement of stock/inventories and their utilization in manufacture process by the assessee has not been furnished, from which a definite inference would have been drawn for that purpose, that the purchase are genuine. Para 7. In that case of the matter, after due verification of the submission, Lordship may kindly mark it, due verification of the assessee and basing materials available on record, it is noted that the income to the extent of rupees 1,41,42,031 has escaped assessment within the meaning of section 147 of the IT Act for the assessment year 1819. Hence is a fit case under section 148. Now, 148 capital A small b has totally been bypassed. No opportunity has been given. Or in the counter affidavit, Lordship will kindly see para 3.6 at page 3 of the counter affidavit. They say opposition of being heard was afforded to the petitioner by this office notice. Again, I'm sorry.
You have other copies?
Yeah,
I have.
Chimaka is there.
For a moment, Lordship may kindly see page 3, para 3.6. Opportunity of being heard, Lordship got it.
Yes, yes.
To the petitioner by this office notice under section 148A, capital S, bracketed small b, dated 12th of March 2022. That is the date on which a show cause notice was issued. So when the opportunity of being heard was given.
Right. All right. All right. Yes, Mr. Chimanka.
Yes, this is my reply. At opportunity given heard.
No, I know. We saw
and
that.
he complied on 14.3. Then assessment has been passed.
All right.
So sufficient opportunity has been given.
All right.
By the
not for sufficient opportunity of being heard. Just give it
getting necessary approval. The petitioner has given an elaborate written submission with as many as 5 annexure in response to the said notice.
All right.
The petitioner has alleged that though he has requested for an opportunity of being heard, the opposite party, without providing the same and without confronting the material collected, has come to the conclusion. Contrary to this apparent of the petition, the information units issue notice 148
you have said that on 12th 2022 we have given, that is the date on which the so-called notice was issued.
Only notice. It is only notice, not so-called notice.
So do you have the objects and reasons of 148A?
Objects and reasons. Well, let's objects and reasons matters. That was that is available in their finance bill matters.
All right, all right. We'll add all that.
Yes, ma'am. On the other day, when this Lordship will remember that 148 notice after 1/4/2021.
Right.
I have furnished that finance bill.
Correct.
And the object and reasons I was explaining to your Lordship on that day, that is 24th of January 2022, when the last hearing took place. And your Lordship adjourned that matter, awaiting the order of the Supreme Court.
Right.
Actually, this is a legislative recognition of JK and Drivenshaft mallards. JK and Drivenshaft, that is 259 at your page 19. Their mallards, Justice Kadri said that the assessee should not be taken by surprise. So when notice under section 148 is issued, the assessee should be given an opportunity to file his objection, and after disposal of the objection, and that also the finance minister in her speech also admitted that yes, in the finance bill, if I remember properly, in the finance bill while introducing the parliament, there also says the honorable finance minister said that yes, we have recognized, given a legislative recognition to the judgment of the Supreme Court in JK and Drivenshaft versus ITO and others.
So no other High Court has interpreted 148A?
No other, at least to my knowledge, not there, man. Yes, yes.
So Bombay High Court has admitted a similar matter where opportunity of hearing and to be heard, which is there, whether it is to be given a physical hearing or not. So that matter is admitted. I was trying to search whether the judgment has come or not, but it just says further proceedings stayed and it is admitted. Unfortunately, I couldn't get it. So one page
statute which uses this word and the Supreme Court has said
your Lordship,
in another case,
small b.
So your Lordship may also take another view of the matter.
In another case,
in another view of the matter, if your Lordship could see 136, section 136 says that all proceedings under this act will be deemed to be judicial proceedings.
No, that's okay.
Malons. So once it is judicial proceedings, 136. No? 136.
131.
So if all matters are judicial, deemed to be judicial proceedings under the act, my humble contention would be this heard, my lord, has to be given a meaning, not confined to issuance of a show cause, my lord. And if your lordship would see, my lords,
My lord, Delhi High Court
proceedings-
has adjudicated one matter, my lord, the order with compilation, my lord, Mr. Sahu, senior.
then if your
Mr.
lordship
Sahu
would
has
see this
filed,
148.
That is page 75.
Sorry.
I am also relying the same, my lord, in my counter.
Gulmohar silk.
Gulmohar silk, my lord.
If-
Page
if-
76 is the relevant.
If your lordship would see this insertion, I'm sorry.
Paragraph 5 and 6, my lord, I am relying on.
Mhm.
No, this is about maintaining 226.
My lord, 148A may kindly see.
No, if your lordship would see 148A, your lordships are asking about the objects and reasons.
148A D.
D no more.
No, if your lordship would see 148A
Yes,
for the
small
for a
B
moment,
also, related.
your lordships are asking about the objects and reasons.
Right.
If your lordship may kindly take up 148, the head note.
Conducting an inquiry. Yeah.
Conducting inquiry, comma, providing opportunity before issuing of show cause under section 148.
No, that's right. But here the word is of being heard.
Of being heard. So providing an opportunity. So that means providing an opportunity of hearing, my lords. And providing an opportunity of hearing, my lord, cannot be akin to mere issuance of a show cause notice, my lords.
Yeah. Correct.
And particularly in my case, I have specifically prayed that before you take an adverse view, kindly afford me an opportunity of being heard. I have specifically made a prayer.
Yeah.
They cannot say that, no, I have not prayed.
No, that is not the point. The point
Yes.
is that the statute require them to or not.
Yes.
And those batch of cases your lordships have seen, like even in cases that statute has not provided, my lord, natural justice has to be read into it, my lord.
No, but that natural justice is a broader concept.
Yes.
See, here there's a show cause notice. Your reply is being sought to the show cause notice, like GK and drive shafts.
Yes.
But if it has
GK and drive shafts do not require a personal hearing. It
Yes.
only said you can file your objections and that will be considered.
My lords, here, my lords, heard is there. My lord, GK and drive shaft judgment, as your lordship
No,
rightly
that
said.
was a judicial order.
My
So
lords.
the procedure the Supreme Court thought of was give a show cause notice, give a notice and let him reply.
Yes.
That's all they said.
But this,
I mean, objections.
It has been stressed little far by this introduction of 148A.
Correct.
It has been stressed.
Which is why I wanted to know if the statement of
That-
objects and reasons says anything.
Yes. Now, actually, this provision is in favor of the assessee, so far as reopening is concerned.
No, it's a protection given to the SSC.
Yes, it's a protection. I'm sorry, ma'am. Loosely, I have used the word.
No, that's okay.
So that the power may not be used arbitrarily in reopening the cases. Therefore, Lordship will also see the time limit. Previously, it was 6 years. Now it is 3 years. And if it is beyond up to 10 years, then section 149 has also been amended. We said that the assessing officer should be in possession that more than 50 lakhs, the assessee has the asset and has not disclosed in his return. Then 10 years can be invoked. And so far as the approval is concerned, my lord, that also may kindly be taken judicial notice. Earlier, my lords, 6 years PCIT, within 4 years JCIT. Now they say that no, it has to be 3 years even PCIT. And more than 3 years, then you have to take the permission of the director or director. So these provision conjointly, if Lordship will read, definitely, my lords, with my humble submission before Lordship is that the assessee should be given an opportunity of being heard, because unless hearing is there, my lords, he cannot now, suppose for example, Midi Steel Limited, an allegation is there, I have made a bogus purchase, or Midi Steel has made a bogus sale. So unless I summon that person under section 131, I can be true, it cannot be ascertained. He has to be the third person's version has been now utilized against me. In that view of that angle of the matter that also can be examined. The department is relying for reopening a third person's version or their books of accounts or any information of the third person. Then unless that is confronted to me and I can summon him, I have got the right to summon under section 131 of the IT Act. Krishna Chalaram's case, lots of will remember that Justice Bhagwati's decision. On the basis of the bank manager statement, the addition was made. And Justice Bhagwati in Krishna Chalaram 125 ITR matters, I'm sorry to, I don't remember the exact page number, but that's a famous case where the bank manager statement was used and the Justice Bhagwati Supreme Court said that, no, you cannot utilize unless the assessee is given a reasonable opportunity to rebut that. It's a fairness of the natural justice, and that is embodied in every statute, manners. Krishna Chand Chelaram's case, my lords.
What happened to Mr. Sahu?
My lord, please, only section 148A D. C and D is very important. Consider the reply of the assessee furnished, if any, in response to SOCO's notice. His reply against the SOCO's notice, I can then decide on the basis of material available record, including reply of the assessee, whether or not it is a fit case to issue a notice under section 148 by passing order with the prior approval of the specific special authority within 1 month from the end of the month in which the reply referred to in the clause C is received by him, or where no such reply is furnished within 1 month from the end of the month in which time is extended, time allowed or to furnish the reply as per the clause B expire.
See, the only thing is, if you read carefully the whole of subclause B,
yes,
just read that.
Yes.
Provide an opportunity of being heard to the assessee by serving upon him a notice to show.
Yes.
So what is this opportunity of being heard by serving him a notice?
Yes, manners. That has provide an opportunity of being heard to the assessee with the prior approval of the specified authority.
No, that's been omitted. That's been omitted.
By serving upon him a notice to show cause within such time as may be specified in the notice, being not less than 7 days, and but not exceeding 30 days.
No. So what I'm saying is, if we simply say provide an opportunity of being heard, that's one thing.
Yes.
By serving upon him a notice to show cause and then specifying within what time the show cause should be
exactly,
issued.
man.
Yes. No. So this opportunity of being heard is by serving a show cause.
Yes. Opportunity of being heard to the assessee with the prior approval of the within such time as may be specified in the notice. By only serving, had the legislative intention being that by serving a notice, it fulfills the object of the act, then they could not have said that.
Ultimately, you have to be given an opportunity.
Yes.
The question is opportunity of being heard.
Yes.
That heard is whether it's physical hearing or
yes.
You could speak. No, you could speak through your reply to the show cause notice. You are speaking in a sense.
Yes. Well, let's just for example, Lordship will kindly visualize another situation in 263. There the commissioner may.
See, being heard is different from giving a hearing, opportunity of hearing to the petitioner. Suppose the word hearing has been used instead of heard.
Hearing.
Would have made a difference. A hearing would mean, because we all understand what a hearing means. Like today, what is now happening is a hearing.
Yes, hearing. Exactly.
So hearing will include somebody coming, arguing, somebody listening to those arguments. All that will be hearing.
Yes.
An opportunity of being heard does not require a physical hearing.
Malice.
That's another way of looking, because the legislature uses no word is redundant.
Yes.
No word is redundant. Provide an opportunity of being heard.
Of being heard.
No. By serving upon him a show cause.
Yes.
So what is the legislature intent? That this opportunity of being heard will be provided by giving you a show cause.
After heard, there's a pause. A comma is there.
Correct.
So if the comma is there, my lords,
yes.
Even if it is by issuing a show cause, my lord, it can't be that this heard, my lords.
No. So heard does not mean a hearing. That's precisely what I'm saying. It's still not being heard.
Your lordship would appreciate a case where, in spite of my show cause, he takes an adverse view, which has civil consequences, my lord. Then where do I go, my lord? Because D, my lord, gives him another power that if he's satisfied with my arguments, or he's satisfied with my show cause, you may drop the proceeding. In one of my cases, which your lordship have kept it to the 10th, I have said that I have got these loans from the banks. Then he gives me a notice saying that you tell the source of my source. How do I explain the source of the bank?
No, that is a completely different thing on merits.
What I was trying to only submit, my lord, is to do away with this arbitrariness, my lord. A chance of personal hearing has to be given, my lord. There are cases, my lord, and I have demonstrated before your lordship and your lordship being satisfied, I have kept that case to the 10th. I have said that Reliance Home Finance was, to just give a rough example, my lord, is one of my source of finance. He says, you give me the source of Reliance Finance. So how do I prove it, my lord? So unless these aspects, my lord, are not gone into in a physical hearing, my lord, my lord, can't exercise his powers under D, which empowers him to appreciate my case, go through the materials and record, and gives him an additional power to drop the proceeding. In most of these cases, my lord, they don't drop this proceeding. On some pretext as other, they continue and issue a show cause notice under 148, my lords. So a valuable right, my lords, which is conferred with great respect under subclause B, is taken away, my lords, and having a consequence.
And as otherwise, lordship also can visualize another thing. As otherwise, in any case, they will issue a show cause. And
that's all they were asked. See, in most cases, that's what is requirement of natural justice. I think just Patnaik wants to ask.
Actually, with regard to clause C, there is no mention as to hearing of the assessee. Kindly come to clause C. Consider the reply of the
consider the reply.
Yes.
Of the assessee furnished.
Maybe a reply in the shape of
if any,
submitted by the
in response to the show cause notice referred to in clause B.
Correct.
Yes.
So, I am obliged, my lords.
Yes.
I am obliged. These are the sequence when one after another. After that, a notice under section 148 is to be issued.
Correct.
These are the first step.
Because you will get one more opportunity. You see, there will be several opportunities. Just let's look at the whole scheme, sir. Let's look at the whole scheme. This is like pre-notice notice. 148 itself is a notice.
Yes.
So now, before 148, there's a 148A notice now.
Yes.
So there is a notice at the stage of 148A. Then there is the actual 148 notice. Then there is this assessment.
Yes.
So you'll be heard of the assessment. Yes. Even at the assessment, you can show all that you're saying, including what Mr. Kare is saying, that you mistook what I was, submitted, or you mistook some fact. All that you show during the reassessment hearing. And when the assessing officer passes an order, he does not have to confirm any addition that he's proposing to make. He can say, I have got a sufficient explanation. So no addition is proposed. The original return is maintained. The reassessment order is no different from the original assessment order.
Mellors, also 148.
No, I'm just saying, so there is already going to be a hearing. If a 148 is issued, you will have a hearing.
148.
So how many hearings are you supposed to have?
Reasonable. Mellors, reasonable. At least 3 of hearing.
Look at the pre. Okay, let us look at the pre 148A regime.
Yes, 148.
The minute you got a notice under 148.
Yes, I filed objection.
No, you asked for reasons.
Yes, I filed return, complied the return.
Reasons were received. You filed objections to the reasons.
Yes.
So GK and Drive Charts made it mandatory that you have to dispose of those objections to the reasons.
Yes.
Without disposing of those objections, you can't proceed with the reassessment.
Correct.
So GK and Drive Charts did not say, having received the objections, you must be given a hearing. That was not GK and Drive Charts.
No.
So only the statute should be presumed to have formalized the GK and Drive Charts judgment to say whatever GK and Drive Charts provided, you will be provided here.
Yes. Mellors, at the same time, Lordship may kindly see, if the assessee is given an opportunity of hearing also, Mellors, let us now not assume how many hearings will be given. Suppose say 1 hearing. I can convince the assessing officer if the physical hearing, which I have given in writing, I can demonstrate it better when I am heard. Just like Mellors, Lordship, virtually Lordship is hearing, but physical hearing I prefer. Physical hearing because I am quite confident that I can convince my lords. So physical hearing, my lords, right from Maneka Gandhi's case, Lordship is aware of that judgment, any number of judgments by Supreme Court. The hearing because civil consequences. And 148, my lords, it is not known whether he will drop or will still proceed with the reassessment proceeding, my lords.
No, it doesn't have. What I'm saying is,
yes,
most of those cases had severe adverse civil consequences, which were kind of irreversible. This is not that kind of a thing. If they disagree with you, with your reply to the show cause notice and still go ahead and give you a 148 notice, that's not the end of the road for you.
No.
In the reassessment, you can still demonstrate to the assessing officer that this reopening is not warranted.
My lords, here, my lords,
so that civil consequences that we talk of,
Binapani Dei's case, my lords,
it's not an irreversible civil consequence.
So my lords, why should the assessee?
Therefore, even this judgment of Justice Chandrachud, under the Himachal Pradesh GST Act, this is about
Para 27 matters. That was there.
No. This is in a slightly different context.
That was
because it's provisional attachment.
Provisional attachment.
So once the result of that procedure that Justice Chandrachud is talking about will result in an attachment or no attachment.
Yes.
Here it is not. It is only notices issue.
Correct, my lords. I bow down. I bow down to what my lord says. But
we can't compare the two things at all in terms of what is the consequence of this procedure.
My lords, Lordship will also kindly keep what I suggesting, my lords. Why should the assessee be subject to the rigors of this assessment proceeding when the fact itself can be demonstrated that your allegation stands falsified? Because I can demonstrate it much better way. Here I have given all the annexes. Lordship will kindly see. Under Annexer 3, I have given all the papers. Now in a 2-page order, he says, Para 6, no, it is not convincing. I will now issue notice under Section 148. Can there be, had he given me, I would have demonstrated before him. And it is not a This is not an e-assessment proceeding. I can go and appear before him. I can unnecessarily an assessee because after 2 years or 3 years, he will raise a demand within the period stipulated under the limitation of the 153 of the IT Act. He will raise a demand, my lords. Then what will happen in that case?
No, we are not on 153A at all here, sir.
No.
We are not on that.
Yes.
Demand comes at the end of an assessment.
Yes.
Assessment means hearing. Nobody is disputing that assessment involves hearing. Reassessment involves hearing. So you're giving a hearing to all that.
Yeah.
There's no difficulty as far as natural justice is concerned on all those aspects.
Yes. I quite
a very
agree.
narrow point here, sir.
Yes.
For satisfying the requirement of natural justice, does it have to be notice plus hearing?
Yes.
Or notice is enough?
Notice is not, my lords.
No. That is, I'm sure you'll argue like that, but that's the question.
No,
the question is, does the statute envisage notice plus hearing or notice?
My lords, had that not been, then the legislature could have said that the assessee will be served with an so-called notice. And without this, we can they can also provide an opportunity.
No. So provide an opportunity of being heard to the assessee by serving upon him.
With the prior notice.
No, that's right. By serving upon him a notice.
Yes, with the prior notice, my lords. Why that is there, my lords? Then if that is the argument to be, that is the logic to be applied, my lords, then this part becomes totally odious. Redundant, my lords. Opportunity means it is an opportunity to be heard.
Because this is not the first time this clutch of words is being used in a statute. I'm sure this was used earlier in the statute, the opportunity of being heard.
Opportunity of being heard means, with great respect to my lord, my lords, means physical hearing. Because, my lords, kindly, now the faceless assessment center has come.
Correct.
Okay.
Correct.
Now, my lords, every assessment has to be done by them, Delhi. Yes. And there is no opportunity of being heard there. And unless, of course, unless the assessee says that I want to be heard during the course of the assessment proceeding. As otherwise, most of the cases, this is never given. Never given. Excepting search assessment or survey assessment.
Yeah. So can I do one thing?
Yes.
You also make further research. Yes. I don't want us to hurriedly decide these issues.
Correct.
Because they'll have ramifications, which is why I asked whether there are other high courts.
Yes.
And also for the statement of objects and reasons, you better
I'll provide
objects and reasons. And also, sir, there could be other statutes. I think we need to do more research on this.
Yes.
There could be other statutes which use a similar word,
correct,
opportunity of being heard.
Or the revenue.
How that has been interpreted by the court.
Yes. That I will run. Other taxing statute.
Yeah. No. So if you read the whole scheme, it seems that it's only
Under Annexure 1, page 11, it is specifically mentioned. I therefore propose to assess or reassess such income or recompute the loss of the
that is, sir,
I hereby require you furnish within 30 days of service of
yes, that satisfies. See, that is borrowed from the statute.
Yes,
the only question is the first expression. Provide an opportunity of being heard.
Of being
what
heard.
Does that mean?
Whether it requires, my lord, physical hearing or not. This is the only
yes.
That's
yes.
the only question. You see, yeah, counsel for the parties require more time to examine the neat legal question that arises for consideration, namely whether, for the purposes of section 148 capital A of the Income Tax Act 1961, an actual physical hearing is envisaged in terms of section 148A bracket small b, or a show cause notice and a reply thereto will satisfy the requirement of that provision. Question mark. Interim orders to continue list on. We'll have it after the vacation?
Yes, yes. By end of June ballots, Lakshmi, keep it.
All right. 29th June.
My lords. Will assist your lordships so
Yes.
far as to reach a
Yeah,
conclusion.
correct.
Your Lordship, may pardon my interruption, my lord. My learned friend, Your Lordship may pardon my interruption, Lord. My learned friend
No,
was-
no, yours will never be an interruption, I'm sure.
We are all assisting the court.
That's all, that's all.
Both the cases.
Both the
Like-
cases.
22 my lord, same my lord.
Both 21 and 22.
22 my lord, I am appearing, I have filed counter affidavit that may be taken.
Yeah, we have taken that. Counter affidavit is taken on record. Both matters. Counter affidavit is taken. on record. Obliged.
Supplementary list item number 23.
My lord, subject to the-
Yes, please.
Yes, my lord. The question has been framed. Notice has been issued in all the cases. And
Oh, already is it?
And my judgment is just applicable to Jammu Development Authority, IT order, then passed Jammu Development Authority High Court order and Jammu Development Authority Supreme Court order. All are in my favor. 8 to 25, page 26 to 27, page 28.
Who's for the other side?
No one has appeared, though issues.
No, notice is not gone.
Yes, please. I filed requisite.
Oh, okay. You say notice returnable. Notice returnable. 11 July. All right. In all these matters.
24.
Yes, yes. All, yeah. 23
All
and
the same.
24. All 24 also, no, sir?
Yes,
24 also.
24 is the same.
For hearing item 25. Item 25.
So, print available. No.
All right. None appears to now.
One pass. Supplementary list passed on matter item number 2. Item number 2.
So despite a passover, none appears to be petitioner. In the interest of justice, list on 17th May. All right.